Hello, 1 2 3 4 1 2 3 4 1 2 3 4 1 2 3 4. Hello.
Hello, 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 1 2 3, hello. Hello,
One, two, three, 1, 2, 3.
Hello, 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 hello.
Check. Hello, hello.
हुजूर, पहले केस में आपको थोड़ा इनकन्वीनियंस मेरे वजह से होगा।
Yes, Mr. Ray.
9:30 बजे हमको मेल पर सब डॉक्यूमेंट आया है। आई हैव नॉट बीन एबल टू गेट प्रिंट आउट ऑफ दोज डॉक्यूमेंट्स।
When do you want, Mr. Ray?
मंडे को कर दीजिए। देवेंद्र बाबू भी मंडे कह रहे थे,
All right.
मंडे कर।
All right, Monday.
My lord, in the connected matter, serial number 1, the pleadings are not complete. Answer is not there, my lord, therefore.
Let it come on Monday, we will see. And in the meanwhile, please.
Although the main issue is same regarding the fixation of revised with retrospective effect.
एक केस, दोनों में एक केस में इनका डिटेल काउंटर एफिडेविट है और इशू सेम है।
And you are appearing in both the cases.
बोथ द केसेस।
One thing more, my lord, which I want to just
इशू एक ही है।
that this is the proprietorship firm and that is the partnership firm.
That doesn't,
That is the only difference. We will see. The difference is between cooperative societies, partnership firm, and HUF.
and
For-
that is not an issue, my lord. Issue is only with regard to enhancement of license fee from a retrospective date.
If you have to file anything in the meanwhile, you may do in the other case also. As jointly requested on behalf of the parties, list these matters on Monday within first 5 cases.
Lordship, my concern, Lordship, I have filed a case. I am elected chairman of the Vyapar Mandal. My election has been declared valid by the deputy registrar on the point that I am defaulter.
Send your mention slip.
Similar issue has been decided by the
Send your mention slip.
Lordship.
Have you? You will have to send it on email of the High Court.
I will send.
Send that.
One consolidated list matter. My lord, one case, my lord, which is listed under the consolidated list of my lord at serial number 1011, my lord. My lord, 20th is the date, your lordship, for
Please send your mention slip.
my lord.
Or mention slips are being taken up day-to-day basis. Send your slip, I will see.
My lord, I had filed a mention slip, my lord, in PDS matter, my lord. Petitioner has filed this writ application. Petitioner
When
self
did you file your mention slip?
on Monday, my lord.
On Monday?
Yes, my lord. He said it is not in the consolidated list, my lord. Since the matter was earlier before a single bench, my lord, now it is before the division bench, my lord.
Yes.
And
Whether it is in the consolidated list of this bench,
no, my lord,
Then
that is
we-
not listed, my lord.
we have
And
no jurisdiction.
my lord, petitioner said another pandemic third wave is approaching, my lord, and
Alright,
despite of
confer-
judicial order, my lord, this is
You
pending.
can confer upon us jurisdiction to entertain your mentions.
No, my lord.
Then only. You cannot.
My lord, one matter in the today's list, my lord, serial number 22. In this case, IE has been filed by the respondents, my lord, and department has taken the same for giving the details, my lord. And
Let it be called.
We had mentioned, I had mentioned my two matters yesterday, but
Let us see. Wait. Your matter may be called or may be called tomorrow. Let us see.
Under the commencing matters, item number 1, CWJC number 12453 of 21, Mr. Anish Kumar. 12453.
minutes. The only ground is that the notice issued by the licensing authority was not.
You should have preferred appeal.
It is not. There are many matters. It has been interfered with.
All right. So tomorrow we will take up the matter as first case.
The only ground is that the notice issued is not in consonance with paragraph 27(3)(2) of the targeted control order.
So that ground is not available to you before the
It can be. We are encouraged if some matters is entertained and the relief is granted. I'm sorry, Lord.
All right. You should discourage them.
हुजूर उतना ही के लिए हुजूर 4-4 साल 3-3 साल लोगों को लग जाता है to get their appeal decided.
This Tuesday. This Tuesday.
Item number 2, CWJC number 18734 of 21, Mr. Krishna Chan.
Plus, it's a no confidence motion matter, and after the removal of the petitioner who was the chief councillor, now the next election is scheduled on 24th. Therefore, any day before 24th convenient to your lordship.
Tuesday.
Tuesday.
Item number 3, CWJC number 19066 of 21, Mr. Anish Kumar.
Lord, this was the matter which was listed before my lords for out of turn hearing, but since it was not in, it was also a no confidence motion.
All right. Tuesday.
Item number 4, CWJC number 19201 of 21, Mr. Rakesh Kumar.
mention on the question of maintainability of the repetition. To be mentioned.
5. CWJC number 20316 of 21, Mr. SSP Yadav.
To be mentioned tomorrow.
Under the heading for order, item number 2, CWJC number 5060 of 21, Mr. Kumar Distributor Private Limited versus the State of Bihar. For the petitioner, Mr. Akash Singh, Mr. Shamishwar Kumar Singh. For the state, Mr. Anurag Singh, standing calling 21.
May I please?
My Lord, yesterday afternoon I have filed the counter affidavit in the registry.
Counter affidavit on behalf of?
The OSD, my Lord.
124.
On behalf of?
I am for the petitioner, my Lord.
No.
Respondent 124, my Lord, state.
1 to 4, one counter affidavit is there.
The supplementary counter.
It is a supplementary counter affidavit, my Lord.
Supplementary?
Yeah.
It is stated by Land Council representing the
Rakesh Prabhat, AC2, AC21.
State of Bihar.
My Lord.
State of Bihar.
My Lord.
State of Bihar. That supplementary counter affidavit has been filed yesterday. Since supplementary counter affidavit is not there on record, discuss matter on Monday, retaining its position along with the supplementary counter affidavit.
Obliged.
हेलो आई परमिट मत लेट हो गया 1 मिनट एक डेमोलेशन मैटर का मेंशनिंग था मोशन बेंच पर हम आने में लेट हो गया
मेंशन स्लिप भेजिए देखें सेंड योर मेंशन आप यहाँ नहीं आप मेंशन स्लिप भेजिए मेल से
Under the heading for hearing, item number 3, CWJC number 1848 of 21, Vista Wind Power Transmission versus the State of Bihar. For the petitioner, Mr. Ramesh Kumar Agarwal, Mr. Satish Kumar. For the state, Mr. Lalit Kishore.
May I please your lordship? Lord, the present matter relates to entry tax, my lord. And this matter,
yes,
and this matter has been thrice, my lord, has been remanded to this court, my lord, by the Supreme Court in another matter, my lord, the same issue. Now, my lord, the 9-bench judgment of the Supreme Court has delivered the final order. Now, in view of this judgment, my lord, one point is available to me, which is that the rate of entry tax cannot be more than the VAT. This is the only issue, my lord. Rate of entry, and for this purpose, my lord, I want to place, my lord, the Supreme Court 9-bench judgment, my lord, the last paragraph, my lord, because in the last paragraph, Honorable Supreme Court,
Mr. Agrawal,
my lord.
have you given the citation to the court?
Yes, I have given. I have given, my lord. Yesterday I have given.
All right.
On email, my lord. हाँ नहीं वो हम लिस्ट ऑफ बुक्स दिए हैं हम बल्कि कई बार दिए हैं
May I pass on?
Yes.
It is 2017 volume 12 SCC page 1 and the
ये लीजिए yesterday evening I have sent this. हाँ? नहीं Now, my lord,
Yes.
what happened, my lord, after this, in the 9-bench judgment, my lord, Supreme Court has said that certain points, my lord, decided, and for some point, Supreme Court has said that this will be decided by the regular bench of the Supreme Court, my lord. Regular bench, my lord, the bench which is hearing regularly, my lord. Now, my lord, in that, my lord, Supreme Court has again, my lord, remanded that matter to this honorable court. Not in this case, my lord. In the another case, my lord, which has been listed before the DB1, my lord.
Yes.
And, my lord, now, my lord, the point which is available, my lord, to me for argument is that whether rate of entry tax can be higher than the rate of VAT, my lord.
Yes.
For that purpose, my lord may see page 621 of the judgment of the Supreme Court.
What is the citation? 2000?
Citation is, my lord, 2007 SCC volume, my lord, 2017 SCC volume 12 from page 1 to, my lord, last page is 621, my lord. Big judgment, my lord, because it was a constitution bench of 9 honorable judges, my lord, and almost all judges have written, my lord, participated in the judgment, my lord. Now, my lord, the question is, my lord,
Yes, yes. Please make your submission.
my lord, on the point of discrimination, my lord, because, my lord, Article 301 of the Constitution says, my lord, that there cannot be any discrimination between the goods which has been manufactured in the state and which has been imported from outside the state, my lord. In these cases, my lord, entry tax has been levied, my lord, on the goods which have been imported from the outside the state, my lord. And that rate is higher than the rate which were being imposed on the sale of that case, goods, my lord, in the state of Bihar, my lord.
Yes.
My lord, now, my lord, I am citing, my lord, the page 621 of the judgment, my lord.
6 to 1. Yes.
Paragraph, my lord, 1159. This is the order of the court. Lastly, my lord, Honorable Supreme Court has done, they have quantified the judgment main points in one page, my lord.
Yes.
And that's 1159, my lord. By majority, the court answered the reference in following terms, my lord. I am reading, my lord, 1159.2. Only such taxes are discriminatory in nature, are prohibited by Article 304A if follows that the levy of non-discriminatory tax would not constitute an infraction of Article 301. Thereafter, my lord, 1159.4. A levy that violates Article 304A cannot be saved even if the procedure under Article 304A or the proviso thereunder is satisfied. My lord, thereafter, my lord, I am relying on 1159.8. Other are for different purposes, my lord, that whether the entire state can be declared a local area or what is the position of tax on the goods imported from outside the country, etc. My lord. Now, my lord, 1159.8. Article 304A throws upon discrimination of a hostile nature in sense and not on mere depreciation. Therefore, incentive set of ETC granted to a specified class of dealers for a limited period of time in a non-hostile function with a view to developing economically backward areas would not violate Article 304A. I am not concerned with this, my lord. Now, the question whether the levies in the present case indeed satisfied the test is left to the determined by the regular bench having the matters, my lord. Now, my lord, when the matter has went to before the regular bench, my lord, regular bench has not decided and they have remanded back this matter to the this honorable court, my lord. Now, my lord.
Where is that?
Hmm?
Where is that?
That order, my lord.
Hello, sir. In one of the cases, Mrs. Harinagar Sugar Mills, in which my learned senior is also appearing. Hello, the regular bench, Honorable DB1, heard the matter and
What we have understood on the basis of what has been submitted is that this 9 judges bench decided the issues and thereafter remanded the matter back to the regular bench of the Supreme Court.
Supreme Court.
Yes.
And then the Supreme Court has in turn remanded the matter back to the High Court. Where is that decision of Supreme Court?
in the matter of Harinagar Sugar Mills itself,
Is that order reported? Decision reported?
Hello, so I am passing on the judgment by the order passed by Honorable DB1 in light of the judgment passed by Honorable 9th Judge Bench, Honorable Supreme Court in the matter of Jindal Stainless. And in this case, the order of remand was by the regular bench of the Honorable Supreme Court. It is not mentioned in the order, but my learned senior has annexed the order passed by the Honorable Supreme Court.
My lord, I have annexed, my lord, now.
And my lords have been pleased to dispose of all those writ application bearing this present writ application, giving liberty to the petitioners to file fresh writ application because the pleading on the basis of the final judgment passed by Honorable Supreme Court is not in the writ application. So it's my humble prayer, my lords may dispose of the writ application with liberty to petitioner to file fresh writ application within 8 weeks or 2 weeks, within 4 weeks or 8 weeks, so that the necessary pleading with respect to discrimination vis-a-vis anti-tax vis-a-vis VAT, because from
Let us
pleading
understand the issue first. We have not completely understood so far the issue involved and the decision, the impact of the decision, division bench decision of this court. Let us see what is there and what can be done.
My lord, I will file, my lord, my junior has. नहीं नहीं ये नहीं एंट्री टैक्स का नहीं नहीं, हरिनगर का एंट्री टैक्स वो वाला फाइल लेके आओ, उसमें जो जजमेंट जो रिमांड हुआ है सुप्रीम कोर्ट से, उसका फोटो कॉपी भी करवा
हरिनगर वाला फाइल बोलिए ना सर।
लेके आओ दौड़ के। उसमें कोई वो है ये जो मैटर जो रिमांड किया है। हाँ
इसका फाइल मंगवाइए ना आप 730।
हाँ मंगवा रहे थे
उसी में है आपका सर।
जल्दी से कौन सी दिए उनको, कौन सा केस
हरिनगर वाला
कोर्ट में कौन सा फाइल किया?
हरिनगर आपका केस जो हरिनगर शुगर मिल, जिसमें कि डिस्पोजल करके फिर से फ्रेश
ओ
ये वाला
नहीं समझ गए।
Yes, Mr. Agrawal, please proceed.
Yes, my lord. Now, my lord, I am bringing that order, my lord. After the
May kindly pass out for the case, madam. Consider for the petitioner, Mr. Pramod Shah. Today
नहीं,
not
कौन
come.
केस कौन केस
Three,
हुआ?
three.
नहीं नहीं 3 नहीं है, ये रेगुलर का चल रहा है, हरिनगर शुगर मिल चल रहा है। नाउ my lord, when this
Mr. Agrawal, let us come to your paragraph 1. What is your relief?
my lord, pardon me,
Please come to paragraph 1.
paragraph,
What is the relief that you have prayed for?
yes, para 1 my lord is my relief, my lord. Para 1, Roman 1 my lord.
Yes.
To issue a writ of certiorari for quashing the notification bearing number so and so 95 dated so and so annexure 2 issued under section 3(1) of the Bihar Entry Tax Act referred so by which entry tax has been imposed on steel towers and tower parts, bolt and nut at the rate of 8%, my lord. My lord, under the, I have sought for quashing of the notification, because by this notification, my lord, rate of entry tax, higher rate of entry tax was imposed at the rate of 8%, whereas rate under the VAT Act is only 4%. And that is the my point, my lord.
So that is the only question which remains to be decided by this court.
My lord?
This is the only question which remains to be decided.
Yes, my lord. Yes, my lord.
And why is it bad as per your submission?
My lord?
Why is it bad? What are the grounds?
My lord, grounds. I am coming to that, my lord. Now, my lord, when the matter
डिसाइड भी हो गया गेहूं के केस में डिसाइड हो गया अभी रिसेंटली हाँ चीफ साहब
oh,
I just inform my lords. Lordship, permit me just to inform one fact, my lord, that this issue, my lord, with regard to the difference in rate, wherein the rate of VAT and rate of entry tax, where there is disparity, the rate of entry tax is higher than the rate of VAT, that matter has also been decided, my lord. By a division bench of this honorable court, by the DB1, my lords, and that in view of the judgment of the Supreme Court, that has been allowed, my lord. And it has been declared that so far as the rate of that notification by which rate of entry tax was higher will not sustain. That has been decided. My friend was also appearing. I appeared on behalf of the petitioner. Just I wanted to inform to my lords.
My lords, it is with respect to SO 32 related with item Atta, Maida and Suji. And it was, we are filing review application against the judgment passed by this honorable court. Because it was with respect to a period prior to 29/8/2006, matters. On 29/8/2006, the issue is what has been decided by Honorable DB1 is with respect to period prior to 29/8/2006, it is discriminatory matters. But after 29/8/2006, it is not discriminatory. Because after 29/8/2006, we have come out with an amendment. We have come out with an amendment that with respect to local areas matters. Local areas, earlier it was outside the state to inside the state. By amendment dated 29/8/2006, the local area has been from within the state of Bihar, one local area, that is municipal area, maybe municipal area, panchayat area, to another municipal area. The local manufacturer here in this state has to pay entry tax. So there is no discrimination after 29/8/2006. This has been held by this honorable court that after 29/8/2006, the provisions of entry tax is not discriminatory. The judgment referred by my senior friend reported in 2008.
He is saying something from my mouth, my lord, that is not correct, my lord. The submission is, my friend's submission is not correct. My lord, I will answer, my lord, each and every thing.
No, but he is only clarifying with respect to some information which was provided
The
by
period.
the
That is not correct, my lord.
No, it is not the period. He is saying now local area has been redefined.
Well,
the
that-
entire state is not a local
My
area,
lord.
therefore discrimination does not
My
arise.
lord.
Traders within the state are also having to pay the same entry tax for local areas specified within the
My
state.
lord.
After
No,
that cut-off date.
my lord, that is not there, my lord.
And no, we would only like
Yes,
to
my
know
lord.
to begin with whether the judgment which has just been, which we have been informed, it relates to a period prior to the amendment or not. That is the only issue.
My
If
lord.
it is prior to the amendment, then there is a scope for hearing. If not, then we
No,
may
my lord,
be-
even after the, my lord, I am submitting, my lord, the discrimination is of two types, my lord. First was on the basis of the statute, and second was on the basis of the notification. On the basis of, my lord, sorry, my lord.
This is 2011 matter. We are
Milord,
in-
after 2000,
Just a
yes,
minute.
sorry,
Just a
sorry.
2011 matter, we have taken up this matter for final hearing today.
Milord,
You don't have a copy of the judgment of the Supreme Court
Milord.
when you have come for final hearing.
Milord, by mistake, Milord.
Mr. Sanjay is referring to some judgment which is not available for us to see. Mr. Vikas Kumar is referring to some decision which is also not there. So this is not the way the matter should be heard.
Milord, that I apologize, Milord.
And
That
that
is,
too
I am,
after when
I am
we
sorry,
are for
Milord.
final hearing of the matter of an old matter like this, every
Milord,
material ought to have been here before us. Because you are right that he cannot make submission orally without referring to any document, but at the same time you also cannot make submission without and refer to a decision of the Supreme Court which is not there with you. The order of remand is not there with us.
Milord. Milord,
So,
Milord,
all right, we will take up the matter on Thursday, next
Milord,
Thursday.
Milord, by that time, Milord, I
Next
will complete
Thursday, let
everything.
there be
But
no
before
confusion.
that, Milord, I am in summary, Milord, what has been decided by the Supreme Court now, Milord, 9 judges, Patna High Court has decided in 2003 itself, thereafter in 2007,
Where?
the reported judgment.
Where?
In 2003,
Where?
Milord,
Where is that reported?
a citation I have given, Milord.
Citation you have given?
Milord, yesterday, Milord, I have passed on through email, Milord.
All right, please do it again. Please give him the
List of books I have
list
given,
of
Milord.
books.
Today I am also giving, Milord. Milord, with proof, Milord, that on 15, Milord, ये लीजिए लिस्ट ऑफ बुक, इसमें 15 तारीख को हम पास ऑन किए, उसका प्रिंट आउट भी लिया है.
All right, we will take up the matter on Thursday. Next.
Milord,
Please, whatever order has been passed in or orders or decisions of division bench or the High Court, whatever the decisions are there, please come.
yes, Milord, Milord, I will, actually, Milord, in the morning I reached from outside, Milord. I could not go my office, Milord, and straightway I have come, Milord, sorry for
Then
that.
you should have said.
Milord, sorry. But, Milord,
One submission I have. Since the writ application was filed way back in 2011, thereafter much water has flown. A final judgment has been passed by Honorable Supreme Court in Jindal Stainless case. Like it is, this case is part of those batch of writ application in which my lords, the Honorable DV1 has been pleased to dispose of with liberty.
We will see whether the same
Yes.
order should be passed in this case also or not. But merely because we have seen this order, we should follow the order. We must apply our mind on the facts of the case and the decision of the Supreme Court.
And after the liberty given by the Honorable Court, the petitioner, they have filed a fresh writ application.
He is not seeking that liberty. Why should we compel him to seek the same liberty? So let us see what is the matter. Let us, as jointly requested on behalf of the parties, list this matter on next Thursday.
Item number 4, CWJC number 665/11, Harinagar Sugar Mill Limited versus the State of Bihar and others. For the petitioner, Mr. Ramesh Kumar Agrawal. For the state, Mr. Pavan Kumar, AC2AG.
Milord, before that, Milord, in the previous case, Milord, I am filing my rejoinder, Milord. That may be kept on record.
File in the registry.
Okay. May I please your lordship? This matter was heard previously, my lord, and my lords have directed the state, after hearing both sides, to ask what rate of interest they will pay. Only for that purpose, my lord, matter was adjourned, my lord. So, state has to disclose only that much.
Only, I will take only 2 or 3 minutes. Let us say the petitioner in present writ application is seeking refund of rupees 37,51,350, which was paid by them as administrative charge under the provision of Bihar Molasses Control Act 1947. And this administrative charge has been deposited by petitioner for the period 5/4/2008 to 36/2008. Whereas the petitioner, they have the prayer of the petitioner for refund of such is in light of the notification as per the requirement of.
Please take your seat, Mr. Agrawal.
Yes, oblige.
It is at page 34, minus annexure 7, minus.
Yes.
The notification at page 34 in exercise of power conferred by section 8A of the Bihar Molasses Control Act 1947 is amended. It is hereby notified that upon establishment of new distillery ethanol plant and expansion of existing distillery plant in the state of Bihar, the administrative charge on all grades of molasses are fully exempted. In case of expansion of existing distillery exemption from payment of administrative charges on molasses shall be confined only to the quantity of molasses which is used for increased capacity of production and shall not be admissible to install capacity prior to expansion, irrespective of production below or at par installed capacity. The above exemption of administrative charge on all grades of molasses will be applicable for a period of 5 years from the date of commercial production of new distillery ethanol plants and expansion of existing distillery plant in the state of Bihar. It's our case, is the case of the state of Bihar, is that this notification is prospective in nature. It is not retrospective. For the reason that before making submission on this issue that it is prospective, my lords, kindly appreciate what is the administrative charge, what that has been exempted. My lords, may ये वाला है, my lords, 307.
अभी जरूरत नहीं है, बैठा होगा।
Yes, what is the administrative charge?
Well, I'm reading the provision of Bihar Molasses Control Act 1947, Velas.
Yes.
Section 8A, imposition of administrative charges on molasses. Notwithstanding contrary contained in Section 8, the state government may, in such manner and at such rates, act as from time to time may be prescribed, impose on any sale or supply of released molasses charges for meeting the cost of establishment. Charge for meeting the cost of establishment or supervision and control over such releases, and such charges shall be recoverable from the person to whom such sale or supply is made. Provided that the state government may exempt or reduce charges in respect of released molasses to the distilleries outside the state of Bihar. For the purpose of this act, any transfer of released molasses from a sugar factory to its own distillery for captive consumption shall be deemed to be supplied. Here in present case, it is the petitioner's, it is a supply from petitioner's sugar factory to its own distillery. So administrative charge for satisfying that exemption is in favor. Exemption can be granted. So for that, firstly we have to that whether there is a liability to make payment of administrative charge or not. So the petitioner is liable to make payment of administrative charge. So first point, we satisfy that the petitioner is liable to make payment of administrative charge. It is satisfied that here in present case the petitioner is supplying from his own sugar factory to the distillery, and it is for the purpose for meeting the cost of establishment. And
whether this notification is applicable in case of the petitioner or
yes,
not.
Yes, Lord Chair. It
is
is
applicable.
It is.
Whether this notification will apply in case of the petitioner
Yes,
from
Lord
the
Chair.
date of production or from the date
Well,
of notification.
For that I am coming. Well, the petition, what has been deposited by the petitioner in form of administrative charge has already been passed on. On meeting the charge on the meeting of cost of establishment and other charges had already been passed on. So in the judgment passed by this court in habeas corpus, since it is related with the provision of VAT coming into effect of VAT Act and the application of the exemption notification issued under industrial incentive policy, fellows have taken note of the judgment passed by Honorable Supreme Court in the matter of Mafatlal's case. So the reliance of this honorable court on the judgment passed is relevant for consideration by this honorable court in present facts of the case. My lords may go through this. It's only prayer.
What is the submission that you are trying to support by that judgment? What is your submission?
My lords, it is that the petitioner, they have deposited the administrative charge before coming to effect, before the issuance of the notification in at page 34. It is dated.
That is a fact, Mr. Vikas Kumar.
9/9/2008.
That is a fact. The amount was deposited.
Yes.
The question is whether this notification shall apply from the date when the production started or from the date of issuance of notification.
Well, it is from the date of issuance. It's
so you can take this plea. This is a legal issue. Whether
it It is prospective in nature. It cannot have a retrospective operation because it is prospective in nature for the reason that the administrative charge what has been deposited by the petitioner before issuance of this notification has been passed on.
According to this is your submission that the amount which you collected illegally is not required to be returned. This is your submission.
It is not illegal, Manus. Because I'm coming to
You were appearing on the last day, Mr. Vikas?
Manus, page 20.
Were you appearing on the last day?
I'm sorry, Manus, I was not there. I have asked.
So who was appearing?
Manus, Mr. Pavan, he is also.
Did he instruct you what the court's query was and why? Are we to go through the entire hearing again every time a new lawyer comes in the same matter?
Manus, I'm
These
sorry.
see 3 pages, come to page 24 of your brief. 11 gha, what does 11 gha say? The incentive policy 11 gha, please read what it says.
It is प्रस्तावित चीनी प्रोत्साहन पैकेज के अंतर्गत किसी विवाद उत्पन्न होने की स्थिति में आयुक्त एवं सचिव गन्ना उद्योग का निर्णय अंतिम माना जाएगा।
अंतिम माना जाएगा। Now come to page 50. What does he have to say? This person who is to have the final say in the matter, what does he have to say at page 50?
वापिस करने के लिए आवश्यक निर्देश देने की it is.
He says return the amount.
Yes.
Now you come to page 65. What you have to say about this, which the Cane department is saying, what have you said about it? Come to page 65. Paragraph 15, no comments. Based on these pleadings, are you in a position to dispute this? Therefore, we had made a pointed query that, look, this is the circumstance. We were expecting that you would have gone through this instead of now starting afresh. What is the concept of administrative charge? That is hardly relevant today. You have said no comments to this. They have said in their counter affidavit that yes, this is our recommendation, and you say no comments. Not denied, not disputed.
The state, on behalf of the excise department, counter affidavit is also on record.
And who is this on behalf of?
It is on behalf of the Cane Commissioner.
No. Therefore, I am saying you have probably not gone through things. See page 61. It is filed on behalf of the excise department, where they say no comments.
Yes, it is on behalf of the excise.
We have to tell you.
So therefore, interest on higher rate than what we had decided on the last date.
It is only one submission. छुआ के पेज 24 छुआ के प्रशासनिक चार्ज से छूट के संबंध में उत्पाद विभाग द्वारा अलग से अधिसूचना निर्गत किया जाएगा एवं उसके अनुरूप कार्रवाई होगी. So it has already been in the guideline itself. It is stated that as the page 24, after issuance of the notification by the excise department.
Mr. Vikas Kumar, if you want to make your arguments for the sake of argument, the matter is different. You may do that. But you can do that at your own risk. the facts are clear, your resolution is there. On acting on your resolution, it is petitioner's case which has not been denied, that the factory was established, the production began, thereafter the notification came, and as per your own resolution, the decision of the Kane Commissioner, Secretary Kane, was to be final.
Yes, it is only the submission by the Kane Commissioner, we have no case.
If you have no case, then you should have said, Kane Commissioner is not a foreigner.
No.
Kane Commissioner is an officer of your, the Secretary Kane is an officer of the state government.
Yes, Lord.
And this is the decision of the state government. Then we will...
with respect to...
Now for the opposition, we will be imposing higher rate.
No, we are not opposing.
You have been opposing. We had, the matter was heard at length. On last Thursday, we had asked Land Council representing the state to inquire.
It is not opposition, my lord.
Yes, you are opposing.
With respect to payment of interest, my lord. Payment of interest. Because the Kane Commissioners, I am addressing on the issue
No, you are
of
not. You are not opposing payment of interest. You are opposing refund itself.
I am mistaken, my lord. I am mistaken. He has said that the issue will be heard by my lord on the question of interest. The Kane Commissioner, order of Kane Commissioner is there. He has asked to make payment. He has asked the Excise Commissioner who happens to be controller of molasses. So in that case, we have the judgment referred by me. My lords, may go through that. It is not with...
Yes. All right.
Which judgment you are citing?
My lords, the copy of the judgment I have given, my lord. It is in habeas part with respect to exceptions, exemptions, my lord. अभी दिए हैं, 2 कॉपी दिए।
Yes.
एक कॉपी उसको दे
Which paragraph?
Hello, so it is at page 6. Hello, so it is at page 6. My lords have quoted the judgment passed in Mafatlal's case. It is with respect to
Yes.
it is reported in 1997 volume 5 SEC 536.
All right.
A claim for refund whether made under the provision of the Act are as contemplated in proposition above or in the suit or writ of in the situation contemplated by proposition above can succeed only if the petitioner plaintiff alleges and establishes that he has not passed on the burden of duty to another person or other persons. His refund claim shall be allowed decreed only when he establishes that he has not passed on the burden of the duty or to the extent he has not so passed on, as the case may be. Whether the claim for restitution is treated as a constitutional imperative or a statutory requirement, it is neither an absolute right nor an unconditional obligation, but is subject to above requirement.
as explained in the body of the judgment. Where the burden of duty has been passed on, the claimant cannot say that he has suffered any real loss or prejudice. The real loss or prejudice is suffered in such a case by the person who has ultimately borne the burden, and it is only that person who can legitimately claim its refund. But where such person does not come forward, or where it is not possible to refund the amount to him for one or the other reason, it is just and appropriate that that amount is retained by the state, that is by the people. There is no immorality or impropriety involved in just appropriation. The doctrine of unjust enrichment is just and salutary doctrine. No person can seek to collect the duty from both ends. In other words, he cannot collect the duty from his purchaser at one end and also collect the same duty from the state on the other ground that it has been collected from him contrary to law. The power of the court is not meant to exercise for unjustly enriching a person. The doctrine of unjust enrichment is, however, inapplicable to the state. State represents the people of the country. No one can speak of the people being unjustly enriched. Yes, since it is with respect to indirect taxation, the judgment referred is here for present. The deposit of administrative charge has already been, for the period in question, has already been passed on. So it's my humble submission.
Passed on to whom?
For meeting the establishment charges and other. It is
even if it is retained by you illegally. Come to page 5 of the judgment you are relying upon. The petitioner was claiming exemption under 1995 policy. In 2005, fresh statute came into play, which instead of granting exemption contemplated deferment. The court has held that deferment is under a subsequent statute, and therefore in those circumstances, in your case it is a illegal retention of money. Contrary to your own stand, how do you apply this case to your case?
It is with respect to that I am relying not this judgment. I am quoting only the judgment relied by this honorable court. Instead of that, I would have.
So any observation can be applied anywhere, irrespective of the facts of the case, or your facts have to come within the four corners of the citation you are relying upon.
Well, it has passed on meeting the administrative charges and
All right, heard. Learned counsel for the petitioner and learned counsel representing the state of Bihar. Unless this matter for judgment on Thursday.
Item number 5, EWJC number 11341 of 2011, Mr. Harbans Private Limited, Central Railway, Judgment for the petitioner Mr. Satyadarthi Next. Near Bhagavad, Mr. Gautam Kejriwal, for the state, Mr. Sunil Kumar Ravi, Mr. D.K. Sinha, Dr. Anand Kumar, Mr. Siraj Kumar.
May please, your lordships.
Yes.
Lords, I have given the list of books. Lords, some earlier orders of this honorable court may also be looked into, my lords. Lords, First is order number 4, 25/8/2011. Originally only railway was pleaded as a party, therefore this honorable court directed the Department of Commercial Taxes to be pleaded as a party. Then, my lords, 26/9/2011 order. इसका बुक्स एक दे दो, इसको भी दिखा दो.
Yes.
And then, my lord, lordship have seen, my lord, 26/9 order, this interim order, and then, my lord, 9/12, wherein the division bench has just briefly set out the issue in question.
Yes.
Lordships. My lords have seen it?
Yes.
My lords. Now the issue is very short in the present case. Pure legal question is involved. Now, my lord, that when neither any sale nor any purchase has taken place within the territorial limit of the state of Bihar, then whether there will be any tax liability attracted within the territorial jurisdiction of the state of Bihar, my lords. Merely because that an administrative office of railway of East Central Railway is situated in Hajipur, from where the tender is awarded for the area beyond the territory of Bihar, that is for Jharkhand and for UP, and the payment is made, whether any amount could have been deducted from the bills of the supplier at Hajipur in Bihar. That is the precise question for consideration. And on such one issue, my lord, identical issue, I say, this honorable court had the occasion to consider and decide. That is annexure 5 to my writ petition, Pandit Ji Electricals case. Similar type of issue was decided by this honorable court. That judgment is at page 30, my lord. But then I will come to that, my lord, later on. I will explain that. But lordship would like to know the facts of the present case so that the law can be applied accordingly, lords.
Unless, before my learned senior may proceed, unless the matter may be adjourned for the day, it may come on the next Thursday. The judgment, they have given 2 judgments. May I go through those judgments for proper assistance to this?
Well, then not next Thursday, my lord, then Thursday after that. I have some personal difficulty.
I have jointly requested list this matter on Thursday करना January का.
In January, my lords?
Yes.
Oblique.
January. Item number 6, TWJC number 23861 of 12, the Union of India and others versus the Shambhu Kumar. For the petitioner, Mr. Srinath Pathak, Mr. Shiv Kumar, Mr. Ravindra Kumar Sharma. For the respondent, Mr. Pankaj Kumar.
Your Lordship, in this case, additional solicitor will argue this case, Your Lordship, and he is on the leg before.
Who is additional solicitor? Who is additional solicitor?
Yes, Your Lordship.
Mr. Counsel, you should have said learned additional solicitor general. Why are you saying additional solicitor?
Additional Solicitor General, Your Lordship, ASG. I will call him, Your Lordship.
How much time will it take?
Kindly password for the day net.
No, we are here.
So,
This is a hearing
I will
matter.
have to, before the Honorable Chief Justice, he arguing the case, Your Lordship. And just I have sent the message to him.
Meanwhile, you can address.
Respondents have appeared.
Respondent has not appeared, Your Lordship. Respondent has not appeared. In a Pankaj Kumar, some name is appearing. Pankaj Kumar, the name is appearing, Your Lordship. केन सिंह है डॉक्टर केन सिंह क्या हुआ क्या
As requested on behalf of the petitioner, list this matter on Thursday next.
I will like to Lordship.
Item number 7, PWC number 61 of 13, the Union of India and others, Arun Chaudhary.
Same prayer, Your Lordship. 7 Union of India on behalf of.
By way of last indulgence, as requested on behalf of the petitioner, Union of India, this matter on Thursday. The matter is adjourned by way of last indulgence, as requested on behalf of the petitioner, Union of India. The matter is adjourned till next Thursday.
8, TWJC number 1875 of 13, the Union of India and others versus the Manoj Kumar and others.
Yes, Your Lordship. Your Lordship, you are asked to that query some that SLP is what is the status of the LPA. This LPA is SLP is pending before Honorable Apex Court, Your Lordship. I have given the printout from the in this case that in the SLP is pending, Your Lordship.
It has been stated on behalf of Union of India that SLP bracketed civil number 23663 hyphen 23668 of 2011 are pending before the Supreme Court. Full stop. In view of this court's order dated 30/9/2013 passed in this case, let the matter be listed after disposal of the said civil appeal bracketed civil number so and so.
I will let you, Lordship.
Item number 9, TWJC number 8726 of 2014, the Union of India and others versus the Manoj Kumar Pathak and others.
In this case, Your Lordship, today Office of Additional Folio has received the file, Your Lordship. Therefore, in the next Thursday, today morning we have received the file. Therefore,
Same order by way of last indulgence.
Lord, let this case may be listed in first week of January, my Lord.
All right, as jointly requested. this matter on first Thursday in January.
Item number 10, CWJC number 11622 of 14, Satyendra Kumar Singh versus the Union of India. For the petitioner, Mr. Rakesh Kumar Tandon, Mr. Manager Shah. For the state, Mr. Ravindra Kumar Salman, CGC.
Do you have the original recording?
Yes,
with you?
yes, Your Lordship. We have recorded. I filed the counter also, Your Lordship. in this.
there is no representation on behalf of petitioner. Learned counsel for the Union of India is present and states that the original records of the departmental proceeding are there in his custody.
Beg your pardon. Original record of department proceeding. No, I have the record of my record is there. Your Lordship. Sorry, beg your pardon. Your Lordship. With my record. Original record of department proceeding is not available with me now, Your Lordship. I will try to bring the record.
First see the order of this court dated 8/4/2017.
I will bring on the next date, Your Lordship. I will bring it on the next date, Your Lordship, the original record.
And counsel for the Union of India is present. List this case on Thursday. First round. List this case on Thursday. The court expects that land counsel for the Union of India should be in a position to produce the original records of the discipline proceeding for the court's perusal if so required on the next date.
Item number 11, CWDC number 15644 of 14, the Union of India and others versus Mr. Mishra for the petitioner. Mr. Kumar Ravi, Mr. Abbas Haidar.
May it please Lordship. My Lord, by the impugned order, the learned CAT, Central Administrative Tribunal, has passed the order passed by the disciplinary authority as well as the order passed by the appellate authority. What has happened in this case, my Lord, the respondent was ASM, Assistant Station Master, and since he was posted at a small station, so he has also to perform the booking role of booking clerk. A complaint was received by the department that he is overcharging the fare, and other lapses are also been done by the respondent. Vigilance Department of the Railway has laid a trap, my Lord, and he had a person was set up who bought 2 tickets of the Jalandhar, and by taking that ticket he charged ₹22 extra. That was supposed to be returned, he had not returned that amount. The second thing, when the accountancy was made, ₹45 was found to be shortage. And the third thing, before joining that window, he has to disclose his personal money. That also he did not do that. On that basis, my Lord, a memo of charge was served upon him. He filed show cause. The 3 charges were, my Lord, charged excess fare, applicant did not declare his personal income, personal money, a shortage of ₹45 in government cash. Annexure 1 is the memo of charge, my Lord. Thereafter, my Lord, inquiry was set up, inquiry report was submitted and disciplinary proceeding was initiated. He filed his show cause and defense statement, my Lord, and thereafter the disciplinary authority imposed punishment. That punishment was, my Lord, to lower his scale punishment reduction of the lower stage for the period of 3 years with postponing future increment. And he filed the appeal, my lord. Appeal was also dismissed. The order of the disciplinary authority was affirmed. Thereafter, instead of filing a revision which was provided under the rule, he preferred this OA. And the learned cat has set aside the orders, my lord, that is annexure 11, page 75.
Where is the inquiry report?
My lord. Inquiry annexure 5, page 50.
50.
Annexure 5, page 50.
15.
50.
50. Yes. No, annexure 50 is nothing. Annexure.
Unfortunately, my lord,
Page 50 is
detailed inquiry report was not annexed. Though I have given this file, my lord, filed by some other person. आपके पास कहीं इंक्वायरी रिपोर्ट हमारे पास भी नहीं
Yes, what is the legality in the order?
My lord.
What is illegality? How the order of the tribunal?
My lord, the learned cat relied upon the provision which was not relevant at that time because that vigilance manual was modified. Annexure 12, I have annexed that the relevant manual, my lord, extract of the relevant manual. It was under the rule 307 and learned cat, my lord, kindly come to page 79. My lord.
CAT or tribunal?
My lord.
Please don't use this expression cat.
Central Administrative Tribunal.
Or tribunal.
Central Administrative
or full
Tribunal.
form Central
Yes, my lord.
Administrative Tribunal. Otherwise, if you have some organization with the abbreviation DOG.
Exactly, my lord. I stand corrected.
Yes.
Page 79 may be seen, the order of the Learned Administrative Tribunal.
79.
79.
Yes.
Paragraph 9 dealt with the manual, my lord.
You could have filed a review. If the tribunal took into account some document, some guideline which was not applicable on that day, you could have sought review.
That is first in.
How the order can be said to be infirm, and that too for a petty matter like this. Why the court should interfere?
No, my lord, the main intention of the Learned Administrative Tribunal was that the witnesses, they should be independent and they must be holding a upper post than the respondent.
And what
Now,
do you have to say about your revised guidelines 307.51? The provision is verbatim, it is one and the same.
Same point has been considered by the division bench of this honorable court, my lord. The railway has taken the same plea in para 5.
307.51 requires that there should be independent witness who should be within a reasonable distance. He should be able to hear, see everything clearly. Where is
my
that
lord,
the
witness was not from that station. Witness was, though it was the railway staff, but he belongs to the Hajipur. So he was not any way connected with that particular station where the respondent was working. I said gazetted officer, the manual said maybe gazetted officer or maybe non-gazetted officer. Though the witnesses belongs to group D, they are the group D staff.
कौन सा है हेडिंग ये? Yes, we'll come back.
Aye. कौन सा चला दिए हैं वही कुछ देर में तो वही स्थापित गाड़ी रिपोर्ट करने लगा इन्फॉर्मेटिव है तो कहेंगे जब वो उसका माइंड मेकअप किया था उसी को पूछना चाहिए क्या चलिए Yes. My lord.
So in similar circumstance,
There is one little, in my lord, the learned tribunal, he relied that the witnesses should be gazetted officer. Though in the previous guideline also, in the amended guideline also, said if the gazetted officer is not available, then non-gazetted officer.
Mr. See, this order was passed on 23/7/2013.
My lord.
The order which has been set aside by division bench of this court is of 18/7/2013 in similar facts and circumstances. Then why should the court interfere? We are bound to follow.
Though
Same principle,
I
same
was
logic.
not aware with this order, my lord.
So it will take hardly 5 minutes to go through.
If my lord is satisfied, then there is no point to I go through it, my lord. If my lord found it that satisfied,
There is one thing that we can pass an order in every case. The other thing is if this petitioner, beneficiary of this case, has been allowed the benefit of the High Court order, then why should you press this application altogether? In every case, why should there be the same order again and again?
In my case, the respondent has already superannuated. In that case, he is still in service.
No, but what that has been, whether this order has been assailed?
No, my lord. That is implemented.
Implemented. Then that is what we want to. That is what his lordship's query is.
After the contempt, my lord, they have implemented. My lord, I was counsel the contempt also.
You can't implement in the case of one and argue in the case of other.
And the second thing, my lord, the revision was also available to him. He has not took the recourse of revision.
The review was available to you. You did not. He went to the tribunal. You have come to the High Court. The Union of India through General Manager East Central Railway, Hajipur, and other officials of Railway have filed the present writ application under Article 226 of the Constitution of India, assailing a judgment and order dated 23/7/2013, passed in OA number 666 of 2009. By the Central Administrative Tribunal, Patna Bench, whereby the application filed by the sole respondent before the tribunal under section 19 of the Administrative Tribunal Act 1985 has been allowed, and the orders dated 9/1/2009 imposing punishment of dismissal.
No, sir. Reduction by lower stage for 3 years with cumulative effect. On that time, I was on page 56. My basic pay was 13610. It was reduced to 1309 for 3 years with cumulative. 13,610 से घटा करके 13,090 कर दिए 3 साल के लिए. No with postponing future increments.
Punishment of reduction of pay to lower stage, that is from 13,610 to 13,090 with postponing further increment was imposed. To stop. The facts of the case in brief are that the respondent was working as an assistant station master at Tharbitia under East Central Railway. So stop. a departmental vigilance raid was conducted on 12/10/2006, leading to initiation of a departmental proceeding with the issuance of charge sheet on 17/1/2007 on the allegation that the petitioner had charged a sum of rupees 500 against 2 tickets in place of 239 rupees 239.
239 each, my lord, is what's 2 tickets. So in place of 478, he charged 500.
And 478, and thus he charged a sum of rupees 22 more than the actual fare from one Ashok Kumar Sahgond, who had acted as decoy. Stop. It was also alleged against him that he did not declare his personal cash, and further a shortage of rupees 45 in government cash was reported. Stop. Next, based on the said vigilance raid, in the departmental proceeding, the charges against the petitioner were held to be proved by the inquiring authority, and subsequently the disciplinary authority imposed the punishment as noted above. Stop. The petitioner's appeal also came to be dismissed by the appellate authority. Stop. The petitioner approached the Central Administrative Tribunal Pasma Patna bench by filing aforesaid OA number 666 of 2009, assailing the order of the disciplinary authority and the appellate authority. Stop. The Central Administrative Tribunal has recorded in its impugned decision that the trap was not held in accordance with the rules prescribed therefore, and therefore the trap itself was illegal, based on which no penalty could be imposed. Stop. The tribunal relied on Supreme Court's decision in case of Moni Shankar versus Union of India and others, reported in 2008, volume 3 SLJ 325. Do you have any SCC equivalent?
Exact page number just
2008, volume 3 SCC 484.
2008 3 SCC 484.
Next. Mr. Sabir Alam, London Council, appearing on Abbas Haider, London Council, appearing on behalf of the Union of India, has submitted that the finding of the tribunal based on non-compliance of the provision under Vigilance Manual dealing with departmental trap cases is unsustainable for the reason that during the departmental proceeding, the witnesses were produced who had supported the allegation of demanding and accepting more money against booking of tickets, by the petitioner, and therefore the said finding could not have been held to be bad on the ground of any breach of the guideline laying down procedure for trap. First off, he has further submitted that the guideline which has been guidelines under the vigilance manual laying down procedure for trap was subsequently amended.
My lord.
Was क्या लिखा?
Has further submitted that the guidelines under the vigilance manual laying down procedure for trial was
Annexure 12.
Learned counsel for the petitioner has submitted that the guidelines relied on by the Central Administrative Tribunal was not in vogue on the date when the raid was conducted, and therefore the impugned order requires interference by this court in the present proceeding.
And may I submit one thing? I just forget me. One decision is also of the Supreme Court, my lord, since reported in 2007, volume 8 SCC, page 212, which says even if assumed that the guideline was not strictly followed, it says that non-adherence of the guideline will not vitiate the departmental proceeding.
So he has referred to Supreme Court's decision. We have not seen that. Where is that decision?
My lord, just why I was not, I couldn't brought that.
We will see. He has referred to Supreme Court's decision reported in 2007,
volume 8 SCC, page 212.
Next, Mr. Dikshit, learned counsel appearing on behalf of the sole respondent, has drawn our attention to a division bench, a coordinate bench decision of this court in case of Union of India versus Dilip Kumar Sinha. Is it reported?
I have not seen that.
Bracketed CWJC क्या लिखा? उसको काट दो. Mr. Dikshit, counsel appearing on behalf of the respondents, has on the other hand relied on coordinate bench decision of this court dated 23/12/2016, rendered in CWJC number 5922 of 2014, to contain that in identical situation relying on Supreme Court's decision in case of Moni Shankar versus Union of India bracketed Supra, this court refused to interfere with the order passed by the Central Administrative Tribunal in seamless circumstance.
It has implemented also.
he has submitted that the order of the tribunal which was under challenge in case of Union of India versus Dilip Kumar Sinha bracketed Supra has since been implemented by the respondents, and therefore they cannot deny the same relief in case of the petitioner. Stop. Next. On perusal of the division bench decision in case of Dilip Kumar Sinha bracketed Supra, we find force in submission made on behalf of the sole respondent. First off, paragraphs 8 and 8, paragraphs 8, 9 and 10 of the said decision are relevant and therefore are being reproduced here and below. Full stop. Next. Considering the aforesaid facts and circumstances and arrival submission on behalf of the parties, we do not find any reason to interfere with the impugned order, judgment and order of the tribunal. Stop. This application is accordingly dismissed.
CWJC number 2188. 21881 of 14, Tribhuvan Jha versus the Union of India. For the petition, Mr. Sunet Kumar Mishra. For the other side, Mr. Ravindra Kumar.
Your Lordship,
yes.
Lordship, I beg for password for the day, Your Lordship, in this case. It was recorded.
We are passing it over for the day, but on the next date it will be impossible for us because we have adjourned at least 7-8 matters today. You can make some alternative arrangement. The matters have come up for final hearing as requested on behalf of the respondent Union of India. By way of last indulgence, the matter is adjourned till next Thursday.
CWJC number 1602 of 15 belong in August. The Union of India versus the Sailor Khatun.
Tailored in the tag matter CWJC number 11969. I have the brief, my lord, and I will argue from that very brief, my lord. Union of India versus Mahendra Prasad. 11969 of 2016. Mahendra Prasad 11969.
Issues are identical. Issues are identical.
Yes, my lord.
Issues are identical.
Yes, my lord.
All right.
almost I did.
The facts are very small, my lord. The petitioners has been appointed on 3/9/1980 as Chowkidar, and 29/11/1989 they have been granted temporary status. And the respondent in this case, that is the private respondent, has superannuated from service on 31/1/2011, working as a Chowkidar.
Temporary status.
Yes, my lord. He has filed this OA number 576 of 2013, and in that case, the OA has been allowed by the Honorable Tribunal on the basis of.
Where for what? What was his relief before the tribunal?
The relief he was asking for the pension and DCRG, and that has been allowed by the single judge order on the basis of a OA which was disposed of on 20, that is OA number 113 of 2006. In that case,
OA number 113.
6, page 5 of the order.
Where is that?
Page 5, OA
You are
number.
arguing 11969.
Yes, my lord.
Are you arguing 11969?
Yes, my lord.
Yes. You are referring to what?
That OA has been allowed by the tribunal on 21/9/2006 with a direction, and on that basis the single judge has allowed that is the direction. The above judgment squarely covers the case of the family pension and pensions so to be made in general. The respondent, ignoring the above cited rulings, denying the claim of the applicant, seems devoid of any substance. In view of the above, this tribunal holds that the substantive merit of the claim in the OA is the result. The respondents are directed to calculate the applicable rule guide terms of the applicable rule and guidelines, admissible pension and retirement benefits to be paid to the petitioner. I rely upon the 3 judgments of this honorable court, my lord. First is (2016) Volume 1 PLJR, page 452. In this case, the court has held that.
2016 volume 1 PLJR.
Yes, my lord, page 452. The work charge employee are not entitled for the pensionary benefit. दिए तो नहीं है सर. State of Bihar versus Bimli Devi. तीनों citation लिख दो. And my lord, the second judgment is 2006 Vol 1 SSC, page 157. Pension and family pension widow of a casual laborer who has acquired the temporary status under the casual laborer scheme in the year 1993, claiming family pension on the ground that her deceased husband, having worked for 20 years, must be deemed to have regular service of the appellant even in absence of the formal order granting him permanent status. CAT accepted that the widow was entitled for the family pension by treating her deceased husband having been regularized in the service on the date of his death. Held CAT view was erroneous as merely on the basis of the length of service of her deceased husband on temporary status, it cannot be deemed that if he had been regularized, further compassionate appointment granted to the appellant to legal heir of the deceased after his death, even if accepted to be regular, that would not alter the status of the deceased service, and therefore the respondent widow will not be entitled to family pension. And the third judgment was Justice S.B. Sinha's order, my lord. AIR
Whether
2000.
the deceased employee was entitled for pension or not.
Deceased employees.
Now he is no more. The employee is no more.
No, in this case, the employee is retired without being regularized on any post. He was on the temporary status, and on temporary status, he has retired.
He had retired. He had earlier filed OA.
Yes, my lord.
113 of 2006.
He was not the petitioner in that case.
He was not the petitioner.
No.
Yes.
Lord, that is 2000 AIR 2000.
Whether this order has been challenged, order of the tribunal dated.
Yes, that has been challenged and upheld by the Honorable Apex Court. That is enclosed with my counter affidavit.
Then why are you arguing? Can you as railway apply different standards to persons in the same organization?
Postal department. It is a postal department.
Or postal department, whatever it is. Those are general propositions of law. In your department, if a particular treatment has been mandated by the court's order and you are carrying it out, can you take a different stand for different employees? There is OA 113 and then there is Meena Devi's case.
Even subsequently also the division bench of this court has...
Yes, that is what I am saying. Then there is Krishna Day versus Union of India, all these cases of your department, and therefore the tribunal has observed that the obduracy of the respondents in ignoring all the above cited rulings.
क्या
How many cases are there?
Six cases.
Six.
There is some difference, a slight difference. All other cases are minor of death. The employee died while in service.
In my case, Milad, I am retired. The case which is going to be taken up, Milad, petitioner is retired and still is served.
So the fact that the petitioner is living is an unfortunate difference.
एक मिनट एक ऑर्डर इसमें है और one order of this honorable court, that is 88/2012, my lord, in this case itself. In that case, Mahendra Prasad was a party, and in that case also the respondents were directed only in the temporary status, my lord, and regularization has not been accepted by this honorable court, my lord. That is CWJC number 2679 of 2012, my lord. The order dated 8/8/2012, my lord. अभी तो एक ही कॉपी है चूंकि फाइल में था.
Your department can file cases because it has money. The government of India has enough money, therefore cases can be filed. This is unnecessary litigation. The Union of India is burdening the court.
Temporary status employee को regularize नहीं किया गया है. As a temporary status is that the rate has been filed single as a result, division bench has rejected, and thereafter the court is asking you are burdening the court with the litigation. There is 3 judgments in our favor that the person working on the work charge second temporary status will not delay. वो कहते हैं कि आपके केस में अदर केसेस अलाउ होगा एंड देयरफॉर यू विल स्टॉप फ्रॉम मेकिंग दिस आर्गुमेंट. My lord, if that's the view, my lord, then one opportunity may be given. I may consult my additional solicitor general.
In the first case, who is appearing in the second case? You are appearing in all the cases.
सब में आप ही पेयर कर रहे हैं petitioner.
नहीं, सब में अलग अलग नेम है.
What is the difference? Is there any difference?
फैक्ट्स तो सबका एक ही है. ऑन टेम्पररी स्टेटस को रेगुलराइज होना है और उनको पेंशन देना है या नहीं. 80 में अपॉइंटेड है, 89 में टेम्पररी.
That is the only question, Mr. Khan. You were referring.
Your Lordship, in my cases, my Lord, the employees died, and my Lord, one ruling has been considered by the tribunal. That is, my Lord, in one of counter affidavit, my Lord.
Departmental ruling is also there.
Yes, sir.
In which case? You are appearing in first case. Sorry.
This is applicable in, my Lord,
Mahendra Prasad case में आ गए.
all the cases.
111-969.
टेम्पररी स्टेटस एम्प्लॉय को भी पेंशनरी बेनिफिट दिया जाना है. A specific rule has been considered in all my cases. My Lord, chapter number 13, benefits for temporary employees. I have provided the book also, my Lord.
Which part of it?
My Lord,
Section P1?
at the top, this is, my Lord, chapter number 13, miscellaneous, benefit for temporary employees. The condition of service of a temporary employees of central government are regulated under the provision of Central Civil Services Temporary Rules 1965 A government servant becomes entitled to pension, retirement gratuity, death gratuity, family pension benefits under the CCS pension rules 1972 only when
status.
he is
Mr.
confirmed
Sir, you are
on
reading, you are reading chapter 13.
Your Lordship.
Chapter 13 of what?
My Lord, that book I have provided in original. किताब दे दिए. My Lord. Swami compilation, which happens to be the reference book.
This is commentary, Mr. Sir.
एक काउंटर में ये रेगुलराइजेशन का एक ऑर्डर है
इसके
और
वजह
दूसरे में टेम्पोररी स्टेटस के
Sub
बाद
para
इसको
one
क्लास 4 का काम करने के लिए
is on retirement from service on superannuation or invalidation after having rendered continuous temporary stroke quasi-permanent service of not less than 10 years. And third one is in the event of death while in service. This ruling has been considered in all my cases by the learned tribunal.
तो वो रोलवा देगा हम लोग को तब
रूल किताब में है पेंशन रूल्स का किताब मंगवाई है
Where is CCS TS rules 1965?
चैप्टर 13 देखिए चैप्टर 13 देखिए कितना पेज का है भाई
टेम्पररी सर्विस
हाँ चैप्टर 13 आपकी किताब में है ही नहीं है
Well, the chronology of the cases are they were earlier casual employee, thereafter they were conferred with temporary status. And in terms of
clear about at least statutory rules.
Your Lordship.
You are referring to this annexure P1, which refers to Rule 10 of CCS TS rules 1965. Where are those rules? Muthu Swami is not parliament.
Exactly, Your Lordship. Today we are not that
And where is the scheme of 15/5/1991? That is also relevant. That provides 50% of services as a temporary employee to be counted for the purposes of pension. So therefore, the court has considered that also, that you cannot be treated as an entrant.
My Lord, in first case, Saida Khatun, that order is at page number 17 in the OA file before landed cat.
जजमेंट के लाइट का
Shahida Khatun, this was OA number 186, the first case on list.
Mr. Counsel, here don't say the OA number, give the CWJC number.
Your Lordship, I am sorry. This is CWJC number
1602.
1602
My Lord, 1602.
ये आपके पास रहता है
ये
इसमें काउंटर है
इसमें काउंटर भी है
इसमें Your Lordship will find annexure.
इसमें काउंटर दिए हैं सर
नहीं, हम OA से बता रहे हैं, OA से बता रहे हैं. Annexure 3 to the OA, it's internal page 17.
यूनियन ऑफ इंडिया फाइल ऑफी का
While allowing, my
फाइल
Lord,
ऑफी का किया है वो होगा
temporary group B status to the employee concerned, everything is written at page number 17.
So you are referring to what?
Well, this order was passed in favor of deceased employee Muhammad Suleiman.
Which page, which pleading, petition, counter, IA, please lead us to the document, then place it. Where is it?
This is page internal page 17 in of OA number 186.
What do you want to convey? What do you want to convey on the
My lord,
basis of this section 2?
after rendering 3 years of service as temporary status, the employee concerned becomes, my lord, entitled for certain benefits. उसमें वो जो counting of service for ये pensionary benefit भी है. That I was referring to.
What is? Please read annexure 2.
Annexure 3 है वो, page number 17. This is memo dated 5/2/2008. In pursuance of
That
the
is page 18, not 17. You are saying page 17?
I am sorry. हमारे में
वही का रिकॉर्ड है।
It says, my lord, in pursuance of Secretary Department of Post New Delhi so and so, communicated through the Chief Postmaster General Bihar Patna, letter number so and so 22/12/92, the casual laborers who have completed 3 years of service in temporary status are entitled to be treated at par with temporary Group D employee. In accordance with the above order, the following casual laborers of the division are treated at par with Group D employee from the date noted against their names. Thereafter, my lord, they are entitled to get the benefits admissible at par with temporary Group D employee from this date, such as, इसमें जो third है, counting of service for the purpose of pension and terminal benefit, as in the case of temporary Group D employee appointed on regular basis for those temporary employees who are given temporary status and who completed 3 years of continuous service in that status while granting them pension and retirement benefit after their regularization. My name, the husband of...
How does it help you?
My lord.
It says after regularization.
My lord, my submission for consideration is that the status became at par with temporary Group D employee. And my lord, from that book, which I have referred, the book also, the benefits available to temporary employee.
सुप्रीम कोर्ट वाला ऑर्डर है। हाँ, सुप्रीम कोर्ट वाला का।
ये यूनियन दो केस है, ये दोनों के लाइक और सब केस भी एडमिट करें।
Paragraph, my lord, in the writ petition, I am referring the impugned order, annexure 6, page number 40, page number 34, annexure 5.
ऐसे नहीं होगा, इसकी 2 कॉपी इसको बनाया जा सकता है।
Para 2, sub-para, your lordship, 7.
Please wait.
Internal page, my lord, 36. Running page 36.
तीन ठो कॉपी अवेलेबल है, एक तो रखा जाए, 2 ठो बढ़ा दिया जाए।
Yes.
However, the circular does not convert
Yes, anything else?
Your Lordship.
Anything else?
My Lord, paragraph 2 I was referring to, my Lord, in the writ petition which is the impugned order. Para 2 ka sub paragraph 2, 3, 4 and my Lord 7. That ruling has been considered and specifically I may be permitted to place your Lordship para 7 at page number 36. It has been submitted that condition of service of temporary employees of the central government are regulated under the provisions of Central Civil Services Temporary Rules 1965. These provide government servant becomes entitled to pension, retirement gratuity, death gratuity, family pension benefit under the CCS Pension Rule 1972 only when he is confirmed on any post. However, in the following cases, temporary government servants are entitled to pension, retirement gratuity, death gratuity, family pension at the same scale as admissible to permanent government servant under CCS pension rules. Schedule 1, 2, 3. One is applicable in the case of Mr. Dixit, he retired. And my Lord, so far my cases are concerned, the third one, in the event of death while in service. And besides, my Lord, several decisions, earlier decisions, have been quoted in Annexure 6. In the case of Meena Devi is Annex, my Lord, page number 43, is on board also. Second case, this is CWJC number 7760 of 15, seriatim में second है.
कंप्लीट लग रहा है।
These are my submission.
ये काउंटर नहीं है,
काउंटर नहीं है
जी। इसमें यह लास्ट वो एक है, इसी पे डिपेंड करते हुए वो पास किया गया। ये 3 ठो कॉपी है, 2 ठो बड़ा सकते हैं हम लोग। आइडेंटिकल क्वेश्चन को डील किया।
नहीं, ये नहीं दिया।
इसे ऊपर से सुप्रीम कोर्ट को लेना है, कौन कोर्ट कर रहा है सुप्रीम कोर्ट का?
वो एक पहले का वो 106 अलाउ हुआ था, उसके खिलाफ रिटायर डिसमिस हो गया, SLP डिसमिस हुआ। सुप्रीम कोर्ट का ऑर्डर तो दिखा, SLP का डिसमिस होना
इंडियन डिसमिस।
हाँ, that doesn't mean that it has been decided.
ये भी वही है ना, उसको सामने रखा जाए, इसको बढ़ा दिया
दूसरा
नहीं, वही है।
ये दूसरा चीज, ये आपका दिया हुआ दोनों ऑर्डर है।
इसका एक और कॉपी होगा ना, यही है क्या? यही 227
उसको जरा बढ़ाइए तो।
ये ट्राइब्यूनल का कॉम्पैशनेट अपॉइंटमेंट के लिए हुए हैं, दैट हैज बीन डिसमिस्ड।
3 ठो तुम बढ़ाए थे।
ये
इसका पैराग्राफ 6 ऑनवर्ड फ्रॉम कंटेंशन एक्सेप्ट
आइडेंटिकल इशू को डील किया है फाइनली।
यही सर्कुलर है, सेम सर्कुलर इज बीन डिस्कस्ड।
इससे पहले ढेर सारे केस जो एडमिट हुआ है, उसमें सुप्रीम कोर्ट के जो जजमेंट का इसका दोनों बढ़ा दिया।
Only I want to add one thing from the basis of judgment which I have given under CWJC 10978 of 2017. The same At case 2, plea was taken before the tribunal by the present petitioner. Same petitioner in this petition. Petitioner that the services of the private respondent was not regularized nor he worked on a regular duty post till his retirement. Therefore, he is not entitled to the pensionary benefit. And all the rules have been taken into consideration by the division bench of this honorable court Milan, and their writ has been dismissed. A very elaborative judgment has been given by the Lordship Milan on earlier occasion also and many other judgments also.
Which decision you are referring to? Same 10.
CWJC 10978 2017. Just I have given here. Second page top at the top. And one judgment of this honorable court has been entered, inclusive by counter affidavit, that has been affirmed by honorable apex. 113 2017. Implemented also.
That will not be treated as a precedence.
They have not been paid pension despite order of the tribunal.
Your Lordship, there is one judgment, Your Lordship, of a division bench, CWJC 227 of 2016. It appears the same circular has been considered, Your Lordships. If Your Lordships would see. From paragraph 6 onwards.
In that case, my lord, myself appeared, and distinction has been made in that case, my lord. I appeared in that case, Suman Singh case. Distinction has been made by your lordship.
Let us see it, then make your submission.
3 साल ही काम किया था.
Let us see then.
My lord.
As far as it appears up till now, after 3 years you acquire that status under the temporary service rules.
My lord.
Up to 3 years you are just a casual.
My lord.
After 3 years you become the temporary service rules. CCSTS starts applying to you.
Your lord. And thereafter, length of service is, my lord, more than 10 years in all the cases.
कंसीडर हुआ है
जजमेंट में तो नहीं कंसीडर्ड
दिए हैं
हाँ
क्या बोलते हैं
तो उसी बात में चले गए कि एक केस में आप सुप्रीम कोर्ट तक हार गए फिर आप दूसरे को क्या नहीं दे रहे ये बात तो बंद ना हो जाता है सर
उसमें नहीं था कि दिस विल नॉट बी ट्रीटेड एज ए प्रेसिडेंट
ऑर्डर में लिखा हुआ
उसी में
इस केस के ऑर्डर में लिखा हुआ है जो केस हम वापस किया डिपार्टमेंट हैज इम्प्लीमेंटेड द ऑर्डर बट इट्स नॉट बी ट्रीटेड एज ए प्रेसिडेंस ये इम्प्यून ऑर्डर में लिखा हुआ है
इम्प्यून ऑर्डर नहीं ना सुप्रीम कोर्ट का बोला
How does it help you, Mr. Singh?
Your Lordship,
the court held that employee having temporary status cannot be treated to be a Group D employee. And for the purpose of grant of pension, there are certain conditions. If an employee in temporary status fulfills those conditions, he will be entitled for the pensionary benefits. But in no case he will be treated to be a Group D employee. He cannot be treated to be a Group D employee. But he still is entitled for pension.
Actually, Your Lordships, I am
Now please come to paragraph 5.
A reference to the said circular would show that inter alia upon completion of 3 years of continuous service with temporary status, the casual employee would get certain benefits of Group D employees. When it comes to retirement benefits, clause 3 of this circular as contained in paragraph 2 thereof clearly stipulates that on completion of 3 years of service in temporary status and after their regularization, they would be entitled to pension and retirement benefits. Therefore, there are two conditions before a temporary status employee gets or becomes entitled to pension. He should have completed 3 years of service as a temporary status employee and must be regularized thereafter. Otherwise, he is not entitled to various other benefits enjoyed by Group D employees as enumerated in the circular. Now, these employees have not been regularized, Your Lordships. So, unless those two conditions are fulfilled, how would they get benefit? Even the rules which my friend has just read out, even they say that he must be regularized.
Where is that?
He was actually, Your Lordships, I'm a bit handicapped. I don't
Please
have.
read Mr. Singh.
That he was reading. कहाँ पढ़ लेते हैं 13 वाला So, I'm sorry, Your Lordship, only when he is confirmed on any post. Only when he is confirmed on any post, Your Lordship.
Please read it.
However, in the following cases, temporary government servants are entitled to pension retirement.
Don't. Please read it slowly, Mr. Singh. There is reason why we are saying this.
However, in the following cases, temporary government servants are entitled to pension, retirement, gratuity, family pension at the same scale as admissible to permanent government servants under CCS pension rules on retirement from service, on superannuation or invalidation after having rendered continuous temporary quasi-permanent service of not less than 10 years, or in the event of death while in service.
A bird's eye view of all the pleadings in the various petitions, it appears that 75% Group D are to be filled up by direct recruitment. And for 25, they are to come through these casual employees.
Your Lordship.
Now the government, central government obviously was alive to their hardship that they keep serving, and therefore they made these temporary service rules that even though you are not a Group D service regular employee, you will get the benefit of pension, and for that purpose beyond 3 years the service 50% will be counted as pensionable service. Now all these cases, they are defeating the very purpose of the temporary service rules. Once they are regularized, where is the question of coming to court? And in some cases you are selectively applying the decisions of the court, and in some cases you are assailing it. And in some cases you have lost up to the Supreme Court. Your
case,
SLPs have been dismissed.
In that case, Your Lordship, my learned friend says that it is not to be treated as a precedent.
That is recorded in the order itself.
As recorded in the order as
Yes, 5 scheme. Top. इस केस में हम क्या करें? हमको तो इम्प्लीमेंट करना ही पड़ेगा।
That particular case, Your Lordship, it says that it is not to be treated as a precedence. Although that is recorded in the order itself.
Order of?
Order of the learned tribunal.
So we are not concerned, even if it doesn't say, that is not a binding precedent for us. How is that relevant here?
Not the Supreme Court.
सुप्रीम कोर्ट का ऑर्डर नहीं देखते हैं सर कैसे
नहीं देखे. Your Lordship, that Supreme Court order we've not seen actually. So
no, it is there. We just saw it. It is in one of the cases which are in your hand.
Your
The
Lordship,
SLP has been dismissed.
Your Lordship, we don't have the copies of all. That is our problem.
That is more the problem of the bench since morning today.
Your Lordship, we are
At least
handicapped,
7-8
Your Lordship.
cases of Union of India have been adjourned just like this.
Your
What we are
Lordship,
asking.
Your Lordship, the problem is, I don't know, it's very embarrassing, Your Lordship, but the problem is we don't have the, we have not received the files. We are in the process of reconstructing those files from here and there. Because we are just trying to reconstruct the files and assist Your Lordships, and we have not been able to reconstruct all the files.
All right, let all these matters come on Thursday.
Your Lordship. नहीं है आप लोग दे दीजिए.
These matters for further hearing on next Thursday. Third Learned Counsel for the parties list these matters for further hearing on next Thursday.
जिसका फाइल है आप ले लीजिए. जो कमी है पिटिशनर से रिक्वेस्ट कीजिए अदर साइड से दे दीजिए.
एक में दिए
Item number 14, CWJC number 4593 of 15, the Union of India versus the Judiciary Mandal.
My lord, if my learned friend have no objection, then it may kindly be taken up on next week.
Next Thursday?
Right.
Yes.
In that case, Your Lordship, I would pray that it may be taken up after vacation, my lord, preferably on after 10th, my lord, any day after 10th.
As jointly requested, list this matter on second week of January, Thursday.
Second week.
50. CWJC number 585 of 50. Ranjit Kumar versus the Union of India and others. For the petitioner, Mr. Anil Kumar, Mr. Satyendra Prasad Singh.
My lord, may I permitted to withdraw this application? The application became infructuous, my lord, because all the grievances had been fulfilled.
Lord Counsel for the petitioner states that this application has become infructuous as the petitioner's grievances have been redressed. So this application stands disposed of accordingly.
16. Along with analogous case, CWJC number 10924 of 15 and CWJC number 2656 of 16. The Union of India versus Alkira. Alkira versus the Union of India. For the petitioner, Mr. Sunil Kumar Sinha. In the second case, for the petitioner, Aruna Prasad Dixit and Mr. Sanjay Kumar Kaur.
Lordship,
Yes,
in
madam.
this case, Lordship, petitioner is reaching the age of superannuation.
Petitioner cannot superannuate.
Lordship, in the year 2000, in the year 1999, Lordship, one OA has been filed before Learned Administrative Tribunal, Lordship.
Madam, this petitioner cannot superannuate.
He,
You are saying petitioner
Lordship,
has super...
respondent has reaching the age of superannuation, Lordship, in this matter. And Lordship, Learned Tribunal has passed one order in the year 2006, Lordship. As per the order, we have all sent intimation letter for fresh and examination conducted for the respondent, Lordship. We have intimated by letter dated 14/8/2006, Lordship, through special messenger. Even we tried to comply the order, but he has not accepted the letter for fresh examination, Lordship. On 21/8/2006, we have sent one special messenger for intimating regarding the schedule of examination is 23rd/8/2006 and 24/8/2006, Lordship, but they did not receive, Lordship, and Learned Tribunal has not noticed such things, Lordship. And now situation is, Lordship, respondent is reaching the age of superannuation. We tried our level best to intimate regarding the examination. Only direction, Lordship, to appear fresh examination has been conducted for the respondent.
You are not assailing the order then? Are you challenging the order?
Yes, Lordship.
No, the order was for you to conduct special examination for him.
Yes, Lordship, regarding that we have conducting a special examination for this respondent, Lordship. Regarding that we have intimated through a letter on 14/8/2006. A letter had been issued by the senior officers of the department, and the examination date has been fixed for 23rd/8/2006. Lordship, for that we have given information to the concerned respondent through special messenger even.
Madam, this order was passed on 11/5/2006.
Yes, Lordship.
By the tribunal.
Yes, Lordship.
Asking you to conduct special examination
Yes,
for
yes.
the respondent.
Yes.
Did you conduct?
Yes, Lordship, we have conduct, and for regarding
Then
this.
why are you challenging the order? You are implementing the order.
Lordship.
You are holding a special
We have-
examination in compliance of the order of the tribunal.
Lordship, after that they come before Learned Tribunal, Lordship. We have given information regarding this examination, but they did not receive the letter.
That is all right. See, on 14th you issued notice to them that
Yes,
exam
Lordship.
is fixed for 23rd.
Yes.
The dispute is that the letter was received by him on 21st. He says 2 days was not sufficient for me to appear in the examination, come from Calcutta and participate in the examination.
Before
The
that, Your
tribunal
Lordship.
in the contempt proceedings have stated
Yes,
that
Lordship.
this is an issue which he may raise. If he wants to raise it, he will raise it. What remains for you? For you nothing remains. If he was aggrieved that that was insufficient opportunity, he could, then it was for him to raise it.
You are challenging this order 8/8/2013.
Yes.
Are you challenging this order?
Yes.
Oh. Yes. This is too much.
Order. Yes, 8/8/13, Lordship, London Tribunal has passed order in CCPA number 53/2007, Lordship, in contempt matter, Lordship. After that order of Learned Tribunal, they have filed one contempt petition before Learned Tribunal, Lordship, and in that case.
So you wanted to be punished?
Lordship.
Why the tribunal could have punished you for non-compliance?
Lordship, we tried our level best from the concerned department, Lordship. They have sent special information regarding the examination, but they have received on 21/8/2006, Lordship, but they refuse because they are not. We have written in our petition, Lordship, compliance of order of order of 19/5/2006 of Learned Tribunal, Lordship. Their written examination date has been fixed for other candidates is 19/8/2006 and 20/8/2006, but for this respondent, Lordship, there is a date of 23 and 24 because he has not received the intimation letter, so special messenger has sent to his house. Yes, speed post from Calcutta to his residence address on 17/8/2006. The envelope containing the letter dated 14/8/2006 was returned and delivered by the postal department. He refused, Lordship, and now he has. There is no latches from the department, Lordship, because we have already arranged one special examination for this particular respondent, and we have intimated. The only thing is
no. You after this order of 8th August 2013.
Yes, Lordship.
Did you fix any other date?
Wait.
And what is your explanation for delayed filing of the writ petition? The order was passed in August 2013.
Yes,
you
Lordship.
filed this writ petition in July 2015. Almost 2 years after passing of the order.
First, I take one instruction from department, Lordship, because.
What instruction?
because no examination.
No contempt proceeding was initiated against you, and you were given liberty to hold fresh examination. If you want, we can direct the tribunal to initiate contempt proceeding against you.
Lordship, as on
after quashing the order.
Lordship, give as a last indulgence, Lordship, one adjournment. I take some instruction from the department, Lordship. Because just I received this file, Lordship, so. Lordship, our plea is, Lordship, रिस्पोंडेंट रिमूव हो चुका है सर, इससे 2008 में रिमूव हो गया है। अरे अभी मैं ही नहीं कर petitioner has already been removed from service in the year 2008, Lordship. 27/6/2008 he has been removed from railway services, Lordship, and has also attained the age in the year 2010.
What is your explanation for delay in filing of the petition?
Lordship, kindly have a look of paragraph 7, Lordship. Petition has already been removed in the year 2008 and he is reaching age of superannuation in the year 2010, 1/2/2010. After that, learned tribunal has passed the order in the year 2013, Lordship.
So when did he retire?
He has been removed from service 27/6/2008, Lordship, and has attained the
27/6/2008.
Yes, Lordship, he has been removed from the railway services, and he has reaching the age of superannuation is 1/2/2010, Lordship, and learned tribunal has passed the order in the year 2013, Lordship, and before that, when they have passed order, Lordship. Annexure 5 and 6 we have annexed in our petition, Lordship. So.
So Dikshit, what your client can get now?
He has been removed, next case has been dismissal, order has been challenged, the next case.
No, in that is a different thing.
His grievance was, he was posted as a permanent way inspector, that is a class 3 post. The railway has arranged selection to the post of Group B, post of assistant engineer. He was initially not called to appear in the examination. He submitted representation before the railway authorities. That kindly call me, allow me to appear in the examination. The railway did not take any heed, They went before the learned tribunal by filing the present OA, The tribunal has allowed the OA direction, call for the entire record. Railway has taken plea that we have served the notice to appear in the examination. Our case was, it is not. The Honorable Tribunal called the entire records of the railway administration and they failed to produce. Thereafter, the Honorable Tribunal has passed an order. You are giving an opportunity to allow the petitioner to appear in the examination. They did not take any heed thereafter also. Then he filed contempt petition. And in the contempt petition, the learned tribunal, instead of taking cognizance of the contempt, has given liberty, taking a lenient view. And after 2 years, they have come here.
No,
It is
Mr.
another thing that
Dixit.
he will be dismissed from the consequential benefit. If the removal order is questioned and set aside, certainly he will get the consequential benefit. Because of the lessons of the railway administration, he did not reach up to the stage of assistant engineer group B.
On 21/8 you received intimation.
No,
By a special messenger.
Wait.
In paragraph 3 onwards, the tribunal has recorded, we have called the record, the railway has failed to produce any document. The document which they produced without any date.
No.
I given undertaking.
Please see the order in CCPA. You have appeared. You have not challenged that order anymore.
Subsequent order in 2008.
Therefore, you received it on 21/8.
Examination was to be taken place at Calcutta 23rd August 6.
All right, so you
and
received
letter
it-
was served 21/8/6.
21/8, yes.
Only one day before. 22 को तो जो हमको 21 को हमको सर्व करना है. How I will went before the at Calcutta from Patna. That's why I have requested to the railway as well as the learned tribunal also. It is impossible for this person. At least 3 days time has to be given.
So
and
on-
thereafter.
On 21/8, did you send any intimation to
Yes,
the
yes.
authorities?
Thereafter the tribunal has passed this order.
On 21/8, did you send any intimation to the authority that today I have received it and I can't comply with this? On 21/8 itself. By what mode?
By hand receipt at Danapur. That's why the tribunal has
You were
given
at
a lenient
Calcutta.
view.
You were at Calcutta.
I went Patna.
At that time, exam was to be conducted. in
And exam was to be taken at Calcutta. That's why the tribunal has taken a very lenient view. Because the tribunal's earlier order is stands. That has not been challenged by them.
But whether the tribunal could have issued further direction, the tribunal had only 2 jurisdictions, while in CCPA either to punish or to exonerate. The tribunal exonerated.
If your lordship,
the tribunal could the tribunal have issued any further direction?
If your lordship,
One and two, Mr. Counsel, your client had attained age of superannuation in February 2010.
Milan.
So where was the question of holding examination in 2013? Why such? Why?
Then railway has to be, without taking examination, railway should have given national promotion. If I was eligible before my superannuation,
yes,
it was railway was bound to hold, grant me promotion nationally without holding selection. If the railway is bound to hold selection, then I have to appear.
Before that, he has already been removed from services.
Now, if my learned friend withdraws the writ petition, then it is well and good.
Well and good.
Otherwise, the order is there, because if I own the next case, certainly consequence will come in the present case.
Certainly, even if we allow your application, the second application is allowed, where is the question of permitting you to participate in departmental examination?
Then railway rules is even without appearing in the selection, national benefit has to be given.
Therefore, in CCPA, the CAT has observed that this is an issue which was not gone into. Who is responsible for non-delivery within time? That is an issue you are required to agitate in the appropriate forum.
Your lordship is quite correct. Instead of taking a lenient view, the tribunal itself has taken a serious view on the contempt.
But department has tried their level best to serve the
In the
intimation.
first
regarding-
case, there is no remedy for you. In the second case, we don't know what will happen.
My request is let the first, it may be adjourned, it may come on Thursday, my second case may kindly be taken up first.
Let us dispose of the first case. She will not press it and we'll leave it to you.
If she is not pressing, then.
And we will leave it to you to take other remedy, whatever remedy is available to you in accordance with it.
Yes. If they are withdrawing, I have no objection.
After some argument, learned counsel for the petitioner decides not to press this application in view of the facts and circumstances. Stop. Our attention, however, has been drawn to the part of the impugned order dated 8/8/2013, whereby the tribunal has issued direction in a fresh direction in a contempt proceeding for arranging special examination for the petitioner. Stop. Next. This application in peculiar facts and circumstances of the case is disposed of as not pressed, with a liberty to the respondent to take appropriate to seek adjudication before appropriate forum as to for whose fault the petitioner could not appear at the special examination fixed.
A special for examination has been
Fixed.
arranged for the respondent lordship.
All right.
Regarding that, we have already tried.
All right. That's next case, CWJC 2656 of 2016 shall be heard on next Thursday.
All right.
दो तो बुक दिए थे जैसे दो तो पेंशन दे दिए वो पेंशन बिल दिए थे
काम करने के लिए जब आप आ जाते हैं तो काम करने के लिए काम करने के लिए वो दूसरे काम ना करते हैं काम करने दूसरा जगह है काम करने के लिए उनको काम करना है काम नहीं होगा
सर कब रखा है ये बता दीजिए
हाँ 23 को
ये वाला
21 को
21 को ये वाला
हाँ कितने केस नंबर है
सर है 18734
हाँ
21 को ठीक
लंच करने जाना है मतलब इसमें से हटा दीजिए हमको भी काम करना इसका काम आप लोग बार डिजिटल करते हैं आगे अभी नहीं नहीं बोलो
खोल लिए, खोल लिए सर, ठीक है। हाँ हाँ सर, लग गया सर, कर दिए सर। हाँ
यहाँ का काम धाम हटवाइए, एकदम ही गलत बात
सर,
है।
एक बार आप बोल दीजिए सर काइंडली।
आएंगे तो हमको बताइएगा।
हाँ, एक बार नहीं बोलिएगा सर।
प्रोसीडिंग में आपको दिक्कत होगा तो ये सब नौटंकी मत करिए।
एक बार आप सर काइंडली नहीं बोलिएगा, ये समस्या हम लोग को ही बढ़ा रहा है लोग। सर हो गया सर।
ये तो मौका नहीं है।
हेलो, यूट्यूब पे क्या ना? हाँ ठीक है, सर को दे देता हूँ। चल रहा है सर, हाँ चल रहा है जी। माइक ऑन है सर, ठीक है सर, एक सेकंड सर बोला माइक ऑन है भाई। माइक बंद कर दो।
सीताराम जी,
माइक बंद हो गया।
सीताराम जी, सीताराम।
Lord, may I have my lords? Mention that
Yes,
I want
yes.
to withdraw. I am not pressing that case. Serial 38, 34 million.
Which item?
34. Grievance has been redressed by the department. Therefore, I am not pressing this.
All right. 34. Yes.
34 B case जो हम
9698. CWJC number 9698.
हाँ उमेश कुमार जी हाँ पार्टी भी बोल
For judgment, item number 23, CWJC number 9706 of 20.
Facts of this case for relevant for present adjudication are brief and not in dispute. Stop. A press communique was issued on 24/11/2018 by the Indian Oil Corporation for selection of regular rural retail outlets for Bihar, including for a location within 3 kilometers from Ali Mode, Kakolat Road, District Nevada, in response to which the petitioner had applied. Oh, stop. One Ruby Kumari had also applied. Oh, stop. On the basis of a lottery drawn on 26/2019, the said Ruby Kumari was declared successful. So stop. The petitioner has filed this writ application seeking direction to the respondents to dispose of a complaint / representation dated 5/6/2020 for inquiring into the selection of the said local petrol pump, said outlet the petitioner is seeking quashing of the process of selection. Stop. selection of said Ruby Kumari for grant of the said outlet. Next.
My lord, during the pendency of the writ applications, my lord, the complaint filed by the petitioner has
Mr.
been...
Counsel, till we conclude the judgment, you will not interfere. Please, please take your seat.
My lord,
Please take your seat. Khalifa. During the pendency of this application, the the petitioner's complaint
24 and 18 redressal grounds.
The petitioner's complaint filed before the authorities has subsequently been rejected by the competent authority. By filing an interlocutory application being IA number 1/2021, the petitioner has sought for quashing of letter dated 5/7/2020, whereby the petitioner's complaint has been rejected. So stop. Next. The brochure of selection of dealers for selection of dealers for regular and rural retail outlets contains inter alia the guidelines on selection of dealers as also grievance redressal system. So stop.
Mr. Counsel, why the provision for grievance redressal is at clause 24 of the brochure?
Yes, Your Lordship.
But the copy which you have supplied later, in that copy it is 18. Both are of November 2018. What is the difference?
my annexure 1 R by 1 starts with PSU Oil Marketing Company's manual, which is missing in the annexure that is provided as annexure 17 to the reply.
Yes.
Perhaps there are two versions of the same, the one that I have been attached, but the core things remain the same, Your Lordship.
No, why in one of the documents it is at clause 18 and in the other it is at 24?
Your Lordship, the mine has been provided by the corporation itself, which is there on their website. They have to ascertain as to how they have brought theirs on record.
Shall we go? The
Even the version number and the date at the bottom right of both of them are the same, Your Lordship. Your Lordship, mine is a manual, his is a brochure.
The-
Perhaps that is the...
said order dated 15/7/2020 has been brought on record by way of annexure 8 to IA number 1 of 2021, from which it transpires that the petitioner had made a complaint to the following effect. Page 40. It is reiterated that no complaint beyond what has been noted above was made by the petitioner invoking the redressal, grievance redressal clause of the brochure. First off, clause 24 of the brochure, which deals with grievance redressal, reads as under: counter affidavit, page 57. '58. First off, from the said order dated 15/7/2020, it appears that the petitioner's complaint was thoroughly inquired into and investigated. Full stop. It appears from the said communication dated 15/7/2020 addressed to the petitioner that not only said Ruby Kumari, the petitioner was also called for a meeting with the investigating officer.
Yes, sir.
IO means investigating officer.
Yes, Your Lordship.
With investigating officer. First stop. It has been concluded, it has been recorded in the said communication that that upon investigation, grievance / complaints / allegations made by the petitioner were not factually correct. Stop. The communication mentions that an intimation later to Ruby Kumari about her selection in the draw of lots was sent to her via email dated 28/6/2019, and on 28/6/2019 another email was sent to her wherein she was directed to submit documents in support of the information provided in her application form. First stop. In her application form, said Ruby Kumari had offered a land which was mentioned to be of one Jagdish Yadav, her father-in-law. First stop. She had submitted Jamabandi of land belonging to said Jagdish Yadav and had also submitted an affidavit in Appendix 3 capital A, which was of the date prior to date of application submission. First off. Next, this is noted at this stage that the application form required a declaration to be given by the applicant to the effect that the land owned by the applicant, क्या लिखा है? A declaration required a declaration to be given in respect of land, nature of land being offered for the purpose of the outlet. So stop. There should be no confusion regarding the two brochures. One which has been provided to us during the hearing of the case, and the other part of which you have annexed with the counter affidavit.
Yes, Your Lordship.
Because we will be referring to say clause 4 of the brochure.
Lordship.
It is the same.
Your Lordship, if Your Lordship may kindly see annexure R by 1 where this brochure starts in my counter affidavit, it clearly says PSU Oil Marketing Company manual, and it was restricted for internal use only. The one that he has brought on record is the brochure and not the manual, which was available to everyone, the applicants also, Lordship.
So then at 18, it should be 18 instead of 24.
It should be.
Insofar as the manual is concerned, it would be 24. That is the instruction that I had received. But if your Lordship wants to
18 likho
refer to a single brochure, then perhaps
all right, because that is for internal use.
Is maybe relied upon.
This is to be noted that clause 4 of the brochure lays down the eligibility criteria. You can take your seat, Mr. Kar. Eligibility criteria for individual applicants, etc. Subclause 5 thereof refers to classification of the applicants into 3 groups based on the land offered or land not offered by them in the application form. Full stop. Group 1 deals with classifies such applicants having suitable piece of land in the advertised location / area, either by way of ownership / long-term lease for a period of 19 years 11 months, or advertised by the oil marketing company bracketed OMC. Full stop. Subclause further clause 4 bracketed Roman 5 bracketed Roman bracketed small e stipulates that land owned by the family members will also be considered as belonging to the applicant bracketed group 1, subject to producing consent letter in the form of affidavit bracketed appendix Roman 3 capital A from the concerned family members. First stop. It has been clarified that parents-in-law for the said purpose shall be treated to be family members. Family members. First stop. There is no dispute, rather this is an admitted position, it is an admitted position, as is evident from the pleadings of the petitioner himself, that the land offered by Ruby Kumari was in the name of her father-in-law, and therefore she was classified as group 1 applicant. Stop. Next, the petitioner has placed heavy reliance on a communication made by the respondents through letter dated 28/6/2019, whereby said Ruby Kumari was asked to furnish certain documents after her selection. Within 10 to 15 10 days. Within 10 days, first of the relevant portion of the said communication reads as under, quote, please note that your candidature is liable to be cancelled in case initial security deposit is not remitted or the document listed above are not submitted within 10 days from the date of this intimation, unquote. Full stop. Subsequently, through letter dated 17/7/2019, a reminder was sent to said Ruby Kumari, intimating her that she had not, that the documents as required by the corporation were not received. First off, she was advised to remit the initial security deposit online and submit specified documents at page documents within 10 days from the date of the said intimation. First off, it was further mentioned that the petitioner's candidature is liable for rejection in case a petitioner saying that private respondent का private respondent shall be liable to be rejected in case she failed to submit the security deposit and the documents within stipulated time. Oh, stop. Learned counsel appearing on behalf of the petitioner has drawn our attention to clause 14 of the brochure, a relevant portion of which reads as under, page 47. Six or seven को note कर लो. Oh, stop. He has submitted that as the private respondent had failed to deposit, to remit the security deposit and furnish the documents as required by the corporation within time, in view of clear stipulation that her candidature was liable to be rejected, there was no occasion for the corporation to have given her further time to file the said documents. First stop. Next. In our considered view, the said submission has no merit at all for two reasons. First stop. Firstly, the petitioner in his complaint, in her complaint, had raised the only objection which has been noted by the authorities while rejecting his complaint. First off. Secondly, the relevant provision under clause 14 of the brochure as on which reliance has been placed on behalf of the petitioner required intimation to the candidates for submission of required documents for conducting land evaluation and field verification of credentials and remittance of 10% of security deposit within 10 days from the date of intimation. First off, it further stipulates that in case the candidate does not submit the document and or remit 10% of security deposit, a reminder will be sent with the notice period of another 10 days that in case the required documents are not submitted, the candidature is liable for rejection. First of further, in case the selected candidates fails to submit the documents and or remit 10% of security deposit, bracketed initial security deposit, comma, within additional 10 days, his candidature will be rejected under intimation. Full stop. Next. This is an admitted fact that the private respondent did remit the security deposit and submit the documents within extended period of 10 days. Pursuant to a communication dated 17/7/2019. First off, this is an admitted fact that the documents were submitted on 22/7/2019. Full stop. Next. Mr. Ankit Katariyar and counsel appearing on behalf of the corporation has relied on a Supreme Court's decision in case of MS Poddar Steel Corporation versus Messrs. Ganesh Engineering Works and others, bracketed AIR 1991 SC 1579, to contain that in any view the condition for furnishing the documents cannot be said to be an essential condition. Full stop. Next. Be that as it may, comma, we are of the view that the petitioner has not made out any case that the grievance / complaint made by him before the authorities against selection of उसको काट देना मिस्टर अंकित कटरियार के ऊपर drawing the court's attention to the averments made in IA number 3 of (2021), Land Council appearing on behalf of the petitioner has attempted to convince this court that on the date of application, the land which the private respondent had offered was not in fact available. Rather, trees were planted over the said land. So stop. For the said reason also, award of the outlet in favor of the private respondent cannot be sustained. So stop. Next, we, on perusal of the materials available on record and consideration of submissions advanced on behalf of the parties and examination of relevant provisions of the brochure in question, we are of the view that the petitioner has not been able to make out any case calling for interference by this court in this matter, for the reason that the specific case of the corporation that the land of the private respondent, that the private respondent was validly classified as Group 1 candidate on the basis of the information furnished in the application and subsequent inquiry / investigation carried out by the officials / representatives of the corporation. So stop. In such view of the matter, we do not find any merit in this application. This application is accordingly rejected. Yes.
My lord.
Huh?
Same thing came in my order, my lord.
It has
Only
come.
one with part of the I want to
Yes,
prayer,
you
my
wanted
lord.
to refer to
My
IA.
additional prayer, my lord.
Counsel, please
My lord.
be kind
Sorry,
to
sir.
us. It is not that we don't read.
No, my lord.
We also read your brief. We also we are equally concerned about correct decision of a case, whether it goes in your favor or against him, against the other side.
Item number, under the heading to others, item number 25. Number 9754 of 21. Mr. Taris P. Elizabeth versus the State of Bihar. On the petition, Mr. Vijay Kumar. Mr. State Pandit for the State of Vikas Kumar.
May it please, my lord. My lord, the petitioner in this case started a manufacturing unit of detergent powder, detergent cake in pursuance of Bihar Industrial Incentive Policy 2011, my lord. My lord, they invested a huge amount. The policy promised that they will be given subsidies and reimbursement under various heads under the policy. My lord, the petitioner also had approval of State Investment Promotion Board for setting up the unit, my lord, and the petitioner, as per all the procedure, was entitled for the subsidies and reimbursement, my lord. The state government stopped the subsidy and reimbursement, refused to give the amount on the ground that the petitioner does not have approval of the competent authority, my lord. My lord, the SIPB is the last authority which has to approve the proposal. This issue of law has been settled by the division bench of this court, my lord. My lord, the order of the division bench is at page 63 of the petition, annexure P8, my lord. CWJC 12104 of 2018, my lord.
Yes.
My lord, this order has also been confirmed by Honorable Supreme Court after the dismissal of SLP, my lord. There is no dispute of law involved in this case, my lord. The facts are not under dispute, my lord. The only issue remains is payment, my lord.
Remains with payment?
Yes, my lord. The issue involved has travelled to Supreme Court. the law is settled as of now that once the petitioner has the approval of State Investment Promotion Board, no other approval is required, my lord.
Then what do you want?
My lord, I want the direction to the respondent for payment of the subsidy and reimbursement amount, as mentioned in my prior one, my lord, of rupees 64 crores 66 lakh 65,434, my lord.
So did you approach them?
My lord, I did. My representation is attached as annexure P7, my lord, page 60.
Page 60?
Yes, my lord. My lord, similar order in this. Yes, my lord.
This is your representation on which date?
My lord, representation was my lord, it was sent on 5/3/2021, my lord.
5/3/2021. Very good. And when did you file the writ petition?
My lord, writ petition was filed soon after the representation, my lord. But
this?
I had approached the authorities before also, my lord.
Where is that?
My lord, may I kindly see the page 30, my lord.
Page?
30.
30?
Yes, my lord. This is 18/12/2020, my lord.
Let us see.
Page 30.
30 is something else.
My lord, so this is after I have approached the authorities. They conducted a meeting. On the meeting also they decided that I don't have approval of the competent authority, so they will not release my money. They have considered the issue, my lord. My lord, and they're also aware of the law which has been settled by this court. My lord can see at serial number 1. They have been considering the issue of some other unit, my lord. And they have noted that...
Just a minute.
Yes, my lord.
So you can pursue that.
Yes, madam.
You can pursue that before the authorities. In view of the decision, if you are relying on that decision, that decision you filed, see, what have you done? You filed the representation on only for the purpose of filing of the writ petition.
Yes, my lord.
You are saying that you filed the representation in March 2021, on 5th of March, and you filed this writ petition on 19/3/2021.
My lord, this is not the case that we brought this issue on, to the attention of the authority on this date only. This is only for record. We have been pursuing this claim for long, and the decision was taken in this meeting after our such approachment to the authorities, my lord.
Let
This,
them take a decision on your representation first.
my lord, the same order may be passed that they should consider the law passed by the Honorable Division Bench and decide my issue.
No.
Are you raising an objection?
No, no. My lords, may I inform that his case is before the Interpretation and Resolution Committee constituted under 2011 policy. My lords,
What remains to be interpreted after the Honorable Court's order?
it is.
You see page 95 of the brief.
I have seen, my lords.
Then there is a clear-cut declaration. Who are the competent authorities?
This committee has been constituted. Honorable Court earlier has taken note of clause 14 of the Industrial
Yes.
Incentive Policy.
Yes, and the 2006 Act both.
In pursuance of that, because what has been submitted by my friend, that in Sunny Star Hotels they have considered the judgment passed by this Honorable Court because and they have taken opinion from the law department. It was opined that similar cases may be treated similar in pursuance of this litigation policy.
State litigation policy.
Yes.
Yes.
So
covered matter. So therefore, that is what my lord is observing. He is saying that since it has to be considered by you, you cannot also shy away from annexure P by 8. It has to be in accordance with.
Altogether 250 cases,
yes,
including this petitioner's case, is before consideration by that committee constituted under clause 14 of the
9 months since he filed the representation, your commitment to economic development.
In 1 or 2 weeks, they are coming with the decision.
If I may, my lord, the review also has been rejected by the Supreme Court. A committee of the Industries Department cannot.
Those issues. The State Council is saying it is pending consideration and final decision will be taken in few weeks.
My lord, if I may, at page 100, the Honorable Division Bench has also opined that once the SIVP has approved, it is not open to interference by any other authority, my lord. My lord, page 100.
Mr. The whole difficulty is that you have quantified the amount.
My lord,
they will be considering your representation. They will decide because we cannot quantify the amount which you are entitled to.
Obliged, my lord. If my lord may see at page 103, a similar order was passed by a single bench of this court, and they have ordered that I may be paid as per my entitlement. They will be free to calculate their amount, my lord. I will not dispute that. If there will be a dispute in that amount, I'll file another petition, my lord. But this objection, the principal objection that on the ground of having not approval of the competent authority, my payment are being stopped, that objection may be removed, my file may be moved further, my lord. I will not dispute the amount, my lord.
He is also saying that the final decisions shall be taken.
Because the issue of competent authority, the issue of the approval of competent authority, that issue has attained finality. But with respect to his entitlement, it has to be decided by a committee. It is being considered. It is my submission.
Which committee is that?
It is Interpretation and Resolution Committee of Industry Department.
What is the name of the committee?
Interpretation and Resolution Committee.
Interpretation?
Yes. It is constituted under clause 14 of the Industrial Incentive Policy. It is at page.
Interpretation and Resolution.
Yes.
Interpretation and Resolution.
Resolution. Committee.
Committee has been constituted.
Yes.
By?
Way back. By the state government. In pursuance of clause 14 of the Industrial Incentive Policy.
Where is that?
Because it is at page 15.
Page 15
of the writ application. My lords have already taken note of this clause, the judgment passed, earlier judgment. 50.
You are referring to page 50
50
of
50 of the writ petition.
50.
in order to clarify and explain any provisions contained in this policy, and for providing solution, a committee should be constituted under the chairmanship of Principal Secretary Industries with the Director of Industries, Director Technical Development, a representative each of the Commercial Tax Department and Bihar.
Which clause you are reading?
Clause 14.
That is why I asked you, what do you propose to clarify once the Honorable Apex Court has approved the decision of the division bench? Why should it go before any interpretation committee? Your Principal Secretary should take a decision on his entitlement. What remains to be interpreted? Whether he is entitled or not, what is the extent, what is the quantum, those things you can examine.
I have informed that his case before filing of his writ application has already been referred to that committee. That committee is considering about 250 cases.
If I may, my lord. My lord.
Since when? Since when this order was order of the revision?
After it attains the finality, against that order we have moved before the Honorable Supreme Court. There it was dismissed. Again we have filed a review application because for us something left, but that has already been dismissed. After attaining the finality of that issue, thereafter we have constituted this committee in terms of the judgment passed.
All right. How much time will it take for you to take a final decision?
In couple of weeks. I have the instruction that in couple of weeks the deliberations of
we are granting you 2 weeks. If you don't take a final decision, the amount which he is entitled to shall accrue interest at the rate of
When you have rejected his claim in 2017, you have not said anything other than the fact that it is not by the competent authority.
No, in 17.
सक्षम स्तर से अनुमोदन प्राप्त नहीं है, इसलिए इकाई को अनुदान की स्वीकृति नहीं दी किया गया.
If I may, my lord.
Just wait. Don't be impatient. Wait. So, in view of the legal position admitted, the admitted position is that this objection cannot be raised.
Yes.
That we can record, that this objection you will not raise, and otherwise you will consider his claim.
That issue has attained.
Yes.
If I may, my lord. My lord, the interpretation committee which they say has been set up, my lord, how can that interpretation committee decide the quantum of the claim, my lord, and eligibility? That clause in the industrial policy, it says specifically, my lord, that the committee will be set up for midterm review of the policy, my lord. Midterm review of the policy. My lord,
Who
this
will
is
quantify it?
the Department of Industries, Director Industries, as per my invoices and everything, they'll quantify, my lord.
Who? Is there any authority prescribed under the policy or anywhere else?
Yes, my lord. The Directorate of Industries, Department of Industries is the secretariat attached to the State Investment Promotion Board.
Where is that?
My lord, that is under Single Window Clearance Act. That is not on record, my lord. Single
Part
window.
of 2011 policy.
My lord, Single Window Clearance Act was brought way back in 2006. And all the industrial policies which have been implemented, all the SIPB was constituted under Single Window Clearance Act, my lord. So that is the mother act, and the policy is passed keeping that act in view, my lord. So that is the Secretariat, Department of Industry will quantify the amount. If there is any dispute, I will not raise that dispute in this writ petition, my lord.
You cannot.
Yes, my lord. That has to be based on my application, they will decide, my lord.
This writ application has been filed seeking direction to the authorities to pay to the petitioner his entitlements arising out of implementation of Bihar Industrial Incentive Policy, 2011 to the tune of rupees 64.6, 66, 65, 434 under the heads of exemption in stamp duty and registration fees, subsidy on investment in plants and machinery, subsidy on investment on plant and machinery purchased for captive power generation DG set, reimbursement for VAT / entry tax paid and reimbursement for GST paid. So stop. Our attention has been drawn to decision of a committee headed by the Additional Chief Secretary, Industries Department, Government of Bihar, in its meeting held on 8/12/2020, whereby the claim of the petitioner 18/12. Our attention has been drawn, sorry, क्या लिखवा रहे थे? Claim of the petitioner for grant of benefit of the incentives under the said policy of 2011 has been rejected on the ground that the investment in respect of the unit in question was not duly approved by the competent authority.
Well, as we'll find at 35, page 35, there is a decision. निर्णय लिया गया कि इस प्रकार वैसे सभी परीक्षित इकाइयों जिसमें सक्षम प्राधिकार का अनुमोदन प्राप्त नहीं है उस पर समेकित रूप से सरकार का निर्णय प्राप्त कर अग्रतर कार्रवाई की जाए.
No, we are seeing the case of the petitioner at page 30. निर्णय लिया गया कि इस प्रकार के वैसे सभी इकाई जिसमें सक्षम प्राधिकार का अनुमोदन प्राप्त नहीं है.
Mr. Vikas, we don't want to relegate him to that position again. That was the position when you were saying that these approvals were not by the competent authority. Today there is no such. So let the department take a decision. Why should it go
We are
back
just
to that
recording what had happened. Stop. You are Mr. Abhishek Kumar?
My lord.
Mr. Abhishek Kumar, learned counsel, appearing on behalf of the petitioner, has relied on a division bench decision of this court in case of Mr. Sunny Stars Hotels Private Limited versus the state of Bihar. Decision of this court dated 29/7/2019, rendered in CWJC number 12104 of 2018, bracketed Mrs. Sunny Stars Hotels Private Limited versus State of Bihar, and other analogous cases, whereby this court has hid in as under page 39. Page 99. Stop. He submits that the said division bench decision of this court has been approved by the Supreme Court also, which fact is not in dispute. Stop. Next. Learned counsel, Mr. Vikas Kumar, learned counsel representing the state of Bihar, has submitted that admits that in view of division bench decision in case of Mr. Sunny Prakash, the reason recorded in respect of the petitioner for refusing his claim to allow incentives no more survives. First off, he has submitted that the decision on the petitioner's claim for giving benefit of incentives under the said Industrial Policy 2011 shall be taken within 3 weeks from today. First off, next, in view of the 3 weeks from today, first off, it appears that the petitioner has made a fresh representation before. Where is that representation?
My lord. At page 60, my lord.
Page 60.
Yes, my lord.
before the Principal Secretary, Department of Industries, seeking release of reimbursement and subsidies under the Bihar Industrial Incentive Policy 2011. Stop. Considering the facts and circumstances of this case, this application is disposed of with a direction to the Additional Chief Secretary or Principal Secretary? The Additional Chief Secretary, Industries Department, Government of Bihar, to ensure that a final decision is taken on the petitioner's claim within 3 weeks from today, and admissible benefits are paid to him within 2 weeks thereafter, failing which the all right.
Obliged. Much obliged. Much obliged.
आज नहीं है, आज एक ही केस है ना, दोनों है।
Monday.
Under the heading for judgment or
Monday.
24. Item number 26, TWJC number 15223 of 21. Mr. Dhaneshwar Nath Construction versus the State of Bihar for the petition Mr. Lal Babu Singh, Mr. Umesh Kumar Gupta for the
May I please be? May I please be? By the impinging order, my lord, the petitioner, who is a registered contractor, my lord, he has been debarred from participating in the future tender, my lord.
Where is
That
the
is
order?
Annexure 7, my lord, at page 37. उपयुक्त विषय के संबंध में अभियंता प्रमुख वन ग्रामीण कार्य विभाग पटना बिहार पत्रांक सो अनुशंसा के आलोक में संलग्न सूची में शामिल संवेदकों को एकरारनामा के निहित प्रावधानों के तहत एकरारी समय के अंतर्गत पूर्ण कार्य नहीं करने के कारण उन्हें विभाग द्वारा डिफॉल्टर घोषित करते हुए अगली निविदाओं में भाग लेने से वंचित किया जाता है। माई नेम अपीयर्स my lord in the next page, my lord, at page 38, my lord, at serial number 9, 10 and 11. My lord, but these works have already been done, completed, my lord. Only maintenance work are to be done, my lord. That is also, my lord, 3 and 4 years have already elapsed, my lord. And admittedly, my lord, they have not paid my bill for maintenance cost, my lord. Whatever I have executed the maintenance work, my lord, they have not paid, my lord. My lord, kindly seek the impinging order, my lord. I have 2 points for consideration, my lord. First point is that, my lord, no notice was served, my lord, upon me as to debarment, my lord, by the engineer in chief, my lord, and without giving any notice, my lord. Second is that, my lord, the debarment can't be forever, my lord. And my lord, the engineer in chief
Why
has.
are you passing such orders? Why are the officers doing this?
My lord, in a case, my lord,
Please
my lord
wait.
have already decided.
My lord has decided sitting singly. Now yes, we can have a different view altogether.
But
We are not bound.
But the issue has already been decided, my lord. Similar order, my lord. Only date is different, my lord. Otherwise, contents are the similar in that impinged order, my lord.
Why?
Lordship, two agreements were executed with the petitioner, Your Lordship. Two agreements were executed and the work is incomplete, Your Lordship. It will be from the impugned annexure itself. It shows 60%. Only 60% work has been done, Your Lordship.
No, he might not have executed even 1% of the work.
Lordship, and
how can you pass order of debarment?
Lordship, two notices were issued to him, that is at annexure A and B of the counter affidavit, and repeatedly he was told to complete it, otherwise this will be the consequence of it. He had the
Where is that consequence?
annexure A and B, Your Lordship, to the counter affidavit. Annexure A, it reads, उपर्युक्त विषय के संबंध में कहना है कि प्रधानमंत्री ग्रामीण सड़क योजना अंतर्गत सो एंड सो पथ निर्माण कार्य को अधूरा छोड़ दिया गया है, अतः उक्त पथ में उपलब्ध सरकारी भूमि पर शेष कार्य अविलंब कराना सुनिश्चित कर, अन्यथा इकरारनामा के सुसंगत कनिकाओं के अनुसार उचित कार्रवाई करते हुए उच्चाधिकारी को सूचित कर दी जाएगी. This is annexure A, Your Lordship, and then annexure B, it reads, Your Lordship, उपर्युक्त विषयक प्रासंगिक पत्र के आलोक में सूचित करना है कि प्रासंगिक इकरारनामा के अनुसार आपको विशंकित पथ का 5 वर्षीय सतत अनुरक्षण कार्य कराया जाना है, परंतु आपके द्वारा इकरारित पथ का सतत अनुरक्षण कार्य नहीं कराया जा रहा है.
सूची में डालने हेतु अनुशंसा कर विभाग में अग्रेतर कार्रवाई हेतु भेज दी
जाएगी. तो उसके बाद रिकमेंड करके भेज दिया गया लॉर्डशिप.
रिकमेंड करके भेज दिया गया, then so called notice ought to have been given to him.
Lordship,
it is simply your recommendation.
Lordship, it was this was treated as a notice to him कि अन्यथा ये हो जाएगा.
You follow the procedure.
Lordship.
You can blacklist him.
Lordship.
But you will have to follow the procedure. Follow it. Issue him notice.
Oblige, Your Lordship. And thereafter we had called him for the measurement, Your Lordship, also. And so everything was done, and thereafter...
You can do anything but in accordance with law. Do it in accordance with law.
Oblige, Your Lordship. That will be done.
Why half-hearted approach? दीवार कर दिया जाएगा, कर दिया गया. Follow the procedure, do it. Do it in a manner that even the courts may not interfere. Issue notice. You can issue notice. You have filed your affidavit?
Yes, Your Lordship. Counter affidavit has been filed, Your Lordship.
So do you intend to blacklist the petitioner in accordance with the procedure prescribed? We will give you liberty.
Lordship, petitioner ought to have, he has his remedies also, Lordship.
What remedy?
What
remedy? You have just debarred. Where will he go? Where will he go? Who is the competent authority? Do you have the rules?
He ought to have, Your Lordship.
Your client, your client may be in trouble. Once they start proceeding against you in accordance with the rules, then it will be difficult for you.
Milord, but as far as this order is concerned, Milord, order of debarment, that is illegal, Milord. That is illegal, Milord, and complete in non-compliance of principles of natural justice.
Have you executed the work?
Milord, I have already executed the work as far as construction work is concerned, Milord.
Yes.
As far as maintenance work is concerned, Milord, that is going on, and that also, Milord, I have completed 2 and 3 years, Milord. Only, Milord, I have completed the work, Milord. Kindly see, I have stated.
What about maintenance?
maintenance for the work, my lord, and for that, my lord, maintenance cost is also fixed with the department, my lord, for per annum, my lord.
You are doing
I have completed for maintenance, my lord, for 2 years, my lord, but they have not paid.
All right.
It is admitted fact, my lord.
All right. File an affidavit. Have you stated?
I have stated, my lord. I have stated. I have stated, my lord.
Where?
My lord, it by read petition itself, my lord. My lord, kindly see para 9.
I am reading para 18.
Para 18 with regard to notice, my lord.
So not you, but the rainy season is responsible for poor condition of
For 1 year, my lord, for a recent period, my lord, for recent period, my lord,
Yes.
only. But as far as last 2 years, my lord, I have done. But for a recent period, my lord, I have stated due to rainy season, my lord, I could not. But that cannot be the ground of debarment, my lord. There is a provision of in the agreement itself, my lord.
What?
They can forfeit my security deposit, they can terminate my agreement. But how can they debar?
Now they can debar. This is the question of the only.
My lord, without
difficulty,
giving any
Mr. Counsel,
notice, without giving any
difficulty
notice.
is that they have so far not followed the procedure. Now they will follow the procedure.
But as far as this order is concerned, my lord, that is bad in law, my lord. That is bad in law, my lord, because in a very, my lord, even and they have debarred me forever. In Kulja case, my lord, there are several cases, my lord, in which the Honorable Supreme Court, even my lords have held out that a contractor cannot be debarred or blacklisted forever. Period is.
So both of you are sharing illegality. You are committing illegality by not executing the work. They are committing illegality by passing orders not in accordance with law. So both of you are sharing.
My lord, I will do. I will complete, and so far he has completed the work. Perhaps my instruction is that
You file an affidavit, then we will consider what to do. That you have executed the entire work. We will see what can be done.
but one order, my lord, I
Which order?
may be permitted to show me a similar order, my
Yes,
lord.
yes, they are not required to show the order, I remember.
No.
We remember other. You are not required to show. We will see, file an affidavit that you have. If we are satisfied that you have done something, then we will see whether to interfere or not.
Then, my lord, in the meantime, operation of the.
In the meantime, are you going to participate any?
There are tenders, my lord,
make out a
have been
case.
floated, my lord.
You are looking at her.
One tender was on 9, my lord. Second is on 29 of this month.
What? Where are these facts? Where are those facts? We are giving you 1 week time. File affidavit. And in the meanwhile, you are also free to initiate action against him in accordance with the procedure prescribed.
Not sir.
So both of you are free. You may file affidavits, he may take action.
So in next week, my lord, this case may be.
Next week, all right. As jointly requested on behalf of the parties, list this matter on 1 week. So you do whatever you want to do.
Yeah, please, Your Lordship.
CWJC 2635 of 20 and CWJC 9153 of 2017 for the petitioner Mr. Mahaswita Chatterjee for the state Mr. Mukesh Kumar.
Yes, madam.
Yes, my lord. Yesterday I was placing before your lordship about the removal and filing of voter list by the society and the final voter list. I will not insist on that, my lord, my lord. Since the election...
Yes.
My lord, ultimately, on the basis of the voter list of 881, the election was held. Election of the managing committee of the society was held on 11/7/17, which was challenged in an election dispute case. And that election was set aside by an order dated 26/9/18. Thereafter, the case begins. Now, today, for your lordship's consideration. Thereafter, the petitioner communicated the election commission to conduct the election, and then started directing the society. In the meantime, the administrator was appointed after the order of setting aside the election was passed, my lord, and petitioners were directed to. It is a continuous process to verifying the records of the society and publish filing objection. I have stated in detail in my petition from paragraph 24 onwards, my lord. Ultimately, the district magistrate constituted a committee and submitted a report with regard to the validity of the removal of the members, 330 members, my lord. And the district magistrate came to the conclusion that yes, there is 6. I have annexed that the report of the inquiry report as Annexure 28, my lord. Thereafter, on the direction issued by the commission as to how the voter list should be prepared, the DCO submitted a list of 631 members, my lord. That is annexure. I am on that. In that, my prayer in the writ petition is that to conduct the election on the basis of the voter list submitted by the DCO by letter number 1252. Page, my lord, kindly come to 36, Annexure 36, paragraph, page number 125.
Which writ petition?
As for the
which case? Which case?
First case, man. First case. That is the relevant case, my lord.
Right. Which page?
2635. Page is 125. And thereafter, I have filed an IA.
You are arguing which matter?
My lord. First case, my lord.
First case is 9153 of 2017.
2635. I was arguing this case yesterday.
All right. So, what about this 9153? What should we do about this?
That is with regard to the order filed by the petitioner earlier to the state election authority for conducting the election
Madam,
on the basis of the voter list submitted by this.
Let us be clear on facts. Which writ petition should be decided first?
First petition, my lord. First one, my lord.
What is the case number of the first case?
2635 is the number. My prayer is that this may be decided first. As I was placing before your love.
No, but your writ petition which was filed in 2017 should be heard first. Why the writ petition filed 3 years thereafter?
May I pray one thing, my lord? I have gone through the briefs. Yesterday I was not, I must confess that yesterday I was not properly prepared. My Lord, on second case is that the petitioner filed a petition before the State Election Authority Chief Election Officer for conducting the election prior to the election held in the year 2017. And in that case, my petition was rejected that the election will be held on the basis of final voter list of 885. Thereafter, on the basis of voter list of containing the names of 881, election was held on 11/7/17. And thereafter, the election was set aside, and what I was placing the development before your lordship.
First case has no relevance now.
The first is the relevant now, because, my lord, after the election was set aside, now the process is going on for five.
First, let us understand which is the first case.
First case, my lord. 2635 is the first case, my lord.
All right. So what should we do about 9153?
9153, a fresh petition was filed by one respondent number 8 for conducting the fresh election on the basis of the 885, and that has been kept pending. No order has been passed by the Chief Election Officer awaiting the result of this case.
Decide this matter first, because this was filed in 2017.
No, my lord, my prayer in first case 2163.
Your prayer, madam. The writ petition which was filed in 2017, we will hear that matter first.
My lord, now I am on pure legal question. I have in IA, I have now, in spite of submitting the draft voter list by the DCO.
Madam, we will not see this CWJC number 2035 of 2020 till we understand the facts of CWJC 9153 of 2017. The relevance of pendency of this writ application.
इसी में तो हुजूर हम कह रहे थे, yesterday I was praying in this case that perhaps I am not sure, I received an instruction that perhaps there is some subsequent development. They filed some petition before the Chief Election Officer again after passing of the order, and perhaps there is some subsequent development. Therefore, I prayed yesterday to bring all these facts on record. Therefore, I prayed for time in this case.
No, sorry. This is to the pending since 2017. We will hear this matter first. We will decide this earlier case first, and then we will take up the other matter. Let us
all
see
right, my lord.
What is the position in this case? Who is appearing for the other side? Yes. Yes. So in the first case, you are challenging some order. Yes. Let us see.
Which one, my lord? First or second case? 9153, my lord.
2017.
Yes, my lord.
Petition filed in 2017.
This case was filed, my lord.
Cause of action survives or not? In 2017, whether the cause of action survives or not?
My lord, cause of action at present does not survive.
Then this application has become
does not survive today. And I
petitioner after some argument states that cause of action no more survives. So accordingly, this application stands dismissed as having become infructuous. CWJC 9153 of 2017. Separate order. Yes. Now let us come to the second case. Yes.
तैयारी की है देखिए तो
Let us come to the second case now. I mean, let us come to CWJC 2635 of 2020.
Yes, my lord. What I was submitting earlier, that CWJC number 2635 has been filed for a direction to the State Election Commission to conduct the election of Sivsagar Prakhand Matsyavi Sahayok Samiti Limited on the basis of the voter list submitted by the district cooperative officer by his letter number 2162 dated 26/19 in compliance of letter number 1375. And my lord, the voter list submitted by the DCO is at page 125, my lord. What I was submitting, that after the setting aside, after the election was set aside by the registrar, a fresh process for election of the society started, and during the course of that, there was verification of the record to judge as to whether the removal of the members was justified or not. Ultimately, the district magistrate constituted a committee, inquiry team, which submitted the report that there is valid member of 631. Thereafter, also the petitioner, the DCO submitted the voter list of 525. Again, that was rejected, and he was directed to file a fresh voter list, and in compliance of that, he has submitted the voter list as contained in Annexure 36, my lord. Page 125. I want to draw your lordship's attention to page 117 at Annexure 33. That is the letter of the commission. That is the letter of the commission directing the DCO as to how the voter list should be prepared. May I read it, my lord? Yes, my lord. निर्देशानुसार कहना है कि प्राधिकार के पत्रांक इतना दिनांक के निर्देशित है कि प्रस्तावित प्रारूप मतदाता सूची सदस्यता सूची 3 भाग में रहेगी.
You are representing state of Bihar. State of Bihar. Yes, and the election authority? Mukesh Kumar. He is not here. No.
Yesterday.
Please send for him. Yes.
Yes, my lord. 3 भागों में रहेगी. एक क विगत निर्वाचन अंतिम मतदाता सूची, अंतर सूची, विगत मतदाता सूची के बाद नए जोड़े गए सदस्यों का सूची एवं विगत मतदाता सूची से हटाए गए सदस्यता सूची. 3 सूचियों के जिक्र करते हुए निर्वाचन में कुल वैध मतदाताओं की संख्या इतना एक विवरणी की आच्छादित रहेगी. And in compliance of this, my lord, the DCO submitted the voter list as contained in Annexure 125, Annexure 36, at page 125.
Yes.
My lord, 125, if your lordship kindly come to the last क ख ग सदस्यता सूची एवं समेकित प्रारूप मतदाता सूची विवरण निम्न प्रकार है. विगत मतदाता सूची के बाद नए जोड़े गए सदस्यों की संख्या 247. विगत मतदाता सूची के बाद नए जोड़े इतना. विगत मतदाता सूची से हटाए गए सदस्यों की सूची इतना. उक्त वर्णित तीनों सूचियों का जिक्र करते हुए निर्वाचन कुल वैध मतदाताओं की संख्या इतना 630. And thereafter, my lord, again there was objection. I have filed an IA petition. My lord, I have filed thereafter, final voter list has been published of 990. I have challenged that also. That is Annexure 45 in the IA petition. 44. IA number 1.
Which are rules which govern election?
21. Rule 21. आइए मेरे पास है ना
Yes, then?
Then, my lord, after my submission, I have filed an IA challenging the final voter list containing the names of 990.
Why?
By the State Election Commission.
Why are you challenging that?
Because, my lord, the after thorough verification and as per the instruction given by the State Election Authority, the DCO submitted the list of 630 now containing the names of voter, my lord. And it is the election authority.
Where is the larger voter list?
Yes.
Where is
that the only question involved in this case that whether the election authority has got any power to include any name in the voter list submitted on behalf of the society. That is a decided ratio, my lord. They are not vested with any power, my lord. 2010 page 650. My lord, I kindly allow me to. It is of course a single bench decision reported in 2010, volume 1, PLGR, page 650. चार और 5
Yes.
Yes, my lord. Yes, my lord. My lord, after the DCO filed submitted the final voter list containing the names of 630, again he was directed to file explanation regarding the validity of the membership. He filed his reply. I have annexed those reply and letter with my IA petition as annexure 41, 42, and thereafter, my lord, without considering those, the final voter list containing the names of 990 has been passed. I have challenged that also, that is annexure 44.
Who are the office bearers as on date?
My lord, at present, there is no managing committee. After the election has been set aside, there is the administrator.
Who is the administrator?
Block extension officer. And he is, the DCO is giving the list after collecting, after the block administrator submits him the details. It is going on behalf of the DCO, my lord.
It is?
Since DCO is being directed by the election commissioner,
yes.
Therefore.
So you want him to continue?
All right, my lord. उसमें कुछ है नहीं, एक ही क्वेश्चन है, whether the after the publication of voter list, after the submission of the list, final voter list, whether the election authority, the election officer has got any power to include any name in the final voter list on his own behalf. Therefore, I was trying to draw your lordship's attention to 2010.
365 persons have been included in the voter list.
Yes.
Why should they not be the voters?
Because they are the removed members, and repeatedly there was verification.
They are removed members.
Then I will start my argument from that tomorrow.
Why?
The committee derives the post power from bylaws number 9. The power is vested to the managing committee.
So you have removed 365
members. 330 members on different reasons.
Just
after following.
Let us understand. You have removed 35 members.
Yes.
From the membership, and therefore they cannot be voters.
Yes.
They cannot be voters because they are not members. Whether they are members or not is a dispute.
No, it is no longer in. That is my submission. I also submitted that yesterday also.
Then let us issue notice to all 335 voters.
No, my lord.
Why?
Then kindly allow me tomorrow to satisfy your lordship as to how no notice is required, and as to how I will place before your lordship many orders passed by this Honorable High Court, and I had the opportunity to appear in those cases, my lord, that if they have been sent to the registrar.
You may be right in your submission on the basis of the decisions of this court, but their views will also required to be taken.
May I please?
Those who have been removed from membership.
Yes, my lord. On that issue, my lord,
yes.
May I place bylaws number 9?
Yes.
May I place bylaws number 9?
Place it.
May I read it, my lord?
Yes.
प्रबंधकारिणी समिति किसी सदस्य की चाल चलन की जांच के बाद और जरूरी गवाही लेकर निम्नलिखित कारणों से किसी एक के लिए जुर्माना कर सकती है, सस्पेंड कर सकती है या निकाली जा सकती है.
Yes.
This is the power vested to the managing committee.
Right.
Yes, my lord.
Whether you have removed them or not, or whether their names have been included in the voter list.
Yes.
They may claim that they are members. So we have a duty to hear them also.
Then I may be permitted to make my submissions on this, my lord. The resolution passed after following the procedure prescribed in bylaws number 9, members were removed by resolution number so and so, and 5 in 2 different meetings, my lord. And the only condition is that to get an approval from Amsabha. And there were 2 Amsabhas after making publication in the newspaper for that Amsabha, and in that Amsabha all the resolution of removal were approved. And after the removal order was passed by the managing committee,
this is admitted. This fact is admitted.
Yes, all these
Who
are
has
admitted. Admitted fact.
Who has admitted?
What I was submitted
Those
before.
who have been removed, they have admitted.
They have not challenged it. Therefore, it has reached its finality. The person who is aggrieved, the person who have been removed by the resolution of the governing managing committee,
yes,
are the aggrieved person.
Yes.
Therefore, they should go before the registrar under section 48 of the Act.
No, they may be under the impression that they have not been removed.
Therefore, the resolution passed by the managing committee becomes final. Their removal becomes final.
Let them come before this court to say that they have been removed. Whether this is a dispute or not is a question to be seen. So let us issue notice to all the 335 persons. You may implead all of them as party respondents.
Kindly allow me to argue on this on tomorrow. 330 कहाँ से करेगा? They have not preferred to.
Every individual.
My lord, I may be allowed to read section 48 then.
What?
48 of the Bihar Cooperative Societies Act.
Yes.
Yes, I am reading it, my lord. Section 48, my lord.
Yes.
If any dispute touching the business of a registered society, other than dispute regarding disciplinary action, so and so, by the society or the managing committee against a paid servant arises amongst members, past members, persons claiming through members, past members or deceased members, and sureties of members, between a member, past member,
Madam,
member के साथ.
Please read the second explanation.
Yes. Second explanation. I will come to that, my lord. I will come to
that. Please.
Yes, my lord. My submission is different, my
Why
lord.
are you evading the reading of the second application?
My lord, my submission kindly.
Madam, we also have a right to submit. Please accept our submissions also. We are making a humble submission to you to read second explanation.
The question whether a person or a person is or was a member of a registered society or not shall be dispute within a meaning of this subsection. The registrar may, on receipt of such reference, decide the dispute himself or transfer it for disposal.
So these 360 persons, if they are not, if you say they are not members.
Yes, I am trying to convince your lordship on this point.
For that, for declaring that they are or they are not, both become a dispute within the
Meaning of
section 48.
Yes.
So you have to go there before the registrar.
My lord, my submission is that the person who passed the order of anything is not an aggrieved person. It is the aggrieved person who is to approach, who was required to raise a dispute. To my understanding, second explanation is also not applicable.
What is Annexure 45?
Annexure 45 is
Yes.
Annexure 44 is the final.
No, we are asking you what is Annexure
Annexure
45.
45.
You want removal of 360 names from the voter list.
Yes.
So which is the forum? You say they are not members. Which is the forum to decide this? You are making an application to the chief electoral officer. How is it possible? You have just read the provision that has to be made before the registrar cooperative. You go there, get this issue decided. This can't be done in a writ proceeding. Yes. Who is the appropriate forum? You are to decide who is the member.
My lord, there are two situations in cooperative society. One is membership dispute and another is voter list dispute. So far membership dispute is concerned, the competition.
She is saying they are not members. वो सदस्य नहीं है.
वही dispute है हुजूर जो आपने कल कहा था. Second
Yes.
explanation of section.
Second
40.
explanation.
Registrar is the competent
They
authority.
will go there. That is all.
My lord, may I submit one thing, my lord? Yes. That what I was submitting, that the result by resolution, the majority.
Just change the name of the addressee on Annexure 45 instead of Mukh Nirvachan. You make it Nibandak. That is all. Nothing has to be done. You want to move, then we will direct immediately or.
All right.
Yes.
This writ application has been filed seeking direction to the Bihar State Election Authority to conduct election of Shiv Sagar Prakand Matsya Jeevi Sahyog Samiti Limited on the voter list submitted by the district cooperative officer through his letter number 2162. District cooperative officer, which district? Rohtas. At Sasaram.
Rohtas, Shiv Sagar.
Letter dated 26/9/2019 in compliance of letter number 1375 dated 4/9/2019 issued by the Bihar State Election Authority. Oh, stop. Next. It appears from the pleadings on record that the petitioner has grievance against inclusion of names of 360 voters in the voters list subsequently prepared for the purpose of the said election. Oh, stop. Next. Ms. Mahasweta Chatterjee, learned counsel appearing on behalf of the petitioner, has submitted that the persons who have been subsequently included in the voters list are not members of the cooperative society, as they were removed in accordance with the bylaws from the membership of the society. Full stop. Next. learned counsel appearing on behalf of the respondents on the other hand has submitted that the petitioner has statutory remedy for redressal of his grievance before the Registrar Cooperative Society under section 48 of the Bihar Cooperative Societies Act 1935. Full stop. Next. On close scrutiny of the provision under section 48 of the Act, we we are convinced that the petitioner, that dispute of the nature can be entertained by the registrar of the cooperative societies, by the registrar within the meaning of the said act. First stop. Second explanation of section 48 of the act makes the situation crystal clear, which reads as under explanation, second explanation 1 and 2. So stop. Next, in such view of the matter, we dispose of this writ application with a liberty to the petitioner to raise dispute before appropriate authority under section 48 of the Cooperative Societies Act of the Act. Stop.
And my lord, one difficulty is there, that now the administrator is there, unless and until there will be any committee, the petition may be allowed. He is not in the committee, my lord, now. The petitioner may be allowed.
Petition may be
Allowed to file the case, not the administrator. Now the society is being represented.
No, any person can raise a dispute. It's a dispute. You can raise the dispute. Any member can raise a dispute.
The time may be friend, my lord. Within 2 months. आप लोग भी तो हाँ? तो प्लीज नहीं करेगा, नहीं इसे नहीं किया टाइम